For withdrawal, Article 47 of the supplementary list.
Yes. Want to withdraw this one?
Lost it.
You, Mr. P. Rahman,
Right.
heard Mr. P. Rahman, the learned counsel for the petition, and also heard MSSH Quorum, the learned petitioner appearing on behalf of state respondent. As per instructions of his client, Mr. Rahman submitted that he wants to withdraw the same. Prayer allowed. The matter is disposed of accordingly on withdrawal.
Hello.
Item 48.
May I please have a look? In this case, Solomon, my love,
Yes.
co-accused in this
And
particular,
CBNC.
yes, fine. Co-accused
here.
in this case, my love, already analyzed on bail. You looks like I will come to page 121, my love. Page 111 part, my love.
Yes.
I am coming to the directly, my love. Paragraph, my love, 4. He submitted by Mr. Larned Counsel that the accused petitioner is innocent, he is not involved in the alleged offense. He is the driver of the vehicle, no knowledge about the contraband recovered from him. He has submitted that he custody so-and-so, 97 2006 girl. Search sheet was filed on so-and-so. Out of my love fix more so till that prosecution could only examine 3 witnesses, which is PW is yet to be cross-examined defense. Further, he submitted that so-and-so, could 3 witnesses number. Last he accordingly have no probability of completion of the trial near future as a lot are yet to be examined prosecution. Therefore, he submitted considering the period of long incursion, the petitioner may be analyzed on bail. Mr. Borman Lanak submitted the fight order that the bail application was rejected. This is my bail application, my lord. And a direction by the court to make the endeavor to dispose of the 6 months. Or even less of 4 months, 8 months, only 3 witnesses were examined in support of so-and-so, judgment has been given. Citing the submitted by Larned Counsel for the petitioner may be granted with a long period of incursion. Paragraph 8, my lord. Have a look at it. 124. Incursion. Further, he submitted the accused petitioner permanent address locality. There is no such absconding will produce the so-and-so. Larned Standing Counsel has submitted investigation collected sufficient material. He confessed before the IO regarding the detail of involvement present petitioner. He further say entire contraband was seized from the conscious possession of the present accused petitioner, my lord. Meaning that Onil Jadhav, my lord. And charge was framed, so-and-so death, 8/5 to the next date evidence, the prayer. Mr. Kyle Sami in a commercial quantity, so the case cannot be denied. I am directly coming para 12, my lord, page 136. Have a lordship. He was not released on merit, my lord. He was released for long incursion violation of Article 21, my lord. In the above, it is submitted Kyle, Larned Standing Counsel. I am coming direct, my lord, operative 19. It is admitted there are some incriminating page 129. Para 19, my lord. It is admitted there is some incriminating material in which from the statement, witness under 6 apart from some other material also being collected. It is also admitted the search sheet was filed statutorily accordingly the search was filed. However, it is a fact that till today, the prosecutor only examined 3 witnesses out of 8 number of listed witnesses according to more trial, vital, but it cannot be denied the effort been made, the Larned single attendance of the witness. In the same way, it is also said several occasions Larned sales on leave was delayed, more so the prosecution as well adjournment of this case. Considering this aspect of my lord, he was released on bail. I am the person, nothing has been recovered from my possession, my lord. And interesting thing, my lord, 3 witnesses were examined. Not a single witness identified. Even I was denied by these officers. I can show your lordship that this person is involved. So considering that I am not going on merit, my lord. Today I am on long incursion, my lord. If the privilege has been given to the same, my lord, benefit should be given to the other accused person. I am relying some judgment, my lord, of the apex court, my lord. Photo to ulta nolaba na. Ki manhoy? Photo to sida sidi olba. It was passed by three judges bench, my lord. B.R. Gabhai, Narasimha, Prasant Kumar. Same matter, my lord. Para 3. Taking into consideration that similarly circumstances accused has already been released on bail, we are inclined to grant bail to the petitioners. And another is that, my lord, it was by the three judges, two judges, Sujjakant. I am not on merit, my lord. Subsequently, go to para 4. We are inclined to release the petitioner on bail only on the ground that he has spent about 2 years in custody and conclusion trial will take some time. Considering that without expressing any view of the merit of the case, once the custody period of the petitioner, the special leave is accepted and petitioner ordered to release on bail, my lord. So my point is 3, my lord. One is that, my lord, co-accused from whose possession the ganja was recovered, he was released on bail, my lord. Second point, till today, the witness were examined. I have annexed all the document, my lord. Not a single witness has said this Amit Kumar is involved in committing the alleged offense. Third thing is, my lord, if, my lord, Long and Garson is released, the accused Ranjit Ki Anil Yadav, then I also, my lord, entitled for the bail. So, considering this aspect, my lord, your lordship may pass my necessary order.
Is my humble prayer, Lordship. Only 1 week may be granted to file our objection, Lordship.
I am not ready.
Lordship, today is the first date, Lordship. We have to inform the department, Lordship. So,
There
Lordship,
is
only
no
1
such
week.
type of law, my lord. I am on, my fundamental right has been violated, Article 21, my lord. That is my only argument before your lordship.
When do you want to?
Lordship, only 1 week, Lordship.
That has been already opined by this honorable court.
1 week only get your detain, I do.
Only that point, my lord.
It should not be. This week, next week only. Because it is a case of such. 17th. Fixing it on 17th. You submit, otherwise he is submitting. I am also have seen the order. But the question is that ground of parity has already taken. Long incarceration, ground of parity. These two are the vital the points he has taken. And but yes, during that period, if there is any further development, that we cannot say.
I have an order of this court.
Otherwise, further development. So that much only you can file any if you want.
I can produce the order of the honorable court, my lord. For it.
Heard Mr. NNB Chaudhary, the learned counsel for the petition, also heard MS so-and-so, the counsel appearing on behalf of the standing counsel NCB. Your good name is
M. Decca.
MDECA, MS MDECA further submitted that they need one week only, 1 week to file their objection. Prayer allowed, list accordingly on 17. 17 invariably you file.
Can it be 16,
If it
my
is-
lord, if possible?
16th, yeah. Oh, okay then.
Yes, my 16, my lord.
16th already.
I am on fundamental right violation, my lord, nothing more than that.
We release starting 1.
In the earlier occasion, Lordship, a report was called for.
That report also we have not received yet, Lordship. It's regarding Jimma of the state LPG cylinder, Lordship.
The report you have not received?
Not received. Otherwise, also, Lordship, whether criminal revision petition lies in respect of an interlocutory order.
Obviously, that is the question also.
It is maintainable, Lordship.
There are some judgments wherein it says that even if it is interlocutory, maybe, but that has to be, what is the question is that in that case, it has to be in a final form, or the rights of the parties has to be there. But here it is purely interlocutory, it seems. You submit on the regard also, because
Right,
he is raising the
right.
point that it's not maintainable,
Right.
and because it's an interlocutory. Instead of filing criminal petition, you have filed revision.
In the meantime, we will again call for the report, Lordship.
Yes. If, I'm just not reflecting in the order sheet. That issue she has already raised, so come prepared with that issue. But obviously it will be after vacation only. We don't have any dates. In fact, it will be after vacation, so let it be fixed on after vacation. Report. You
Immediately
do want
after.
any date fixed or you want any fixed date here?
Lordship, immediately after the vacation.
Immediately after the
Lordship.
vacation. Immediately after vacation. Okay. Report not received. Issue reminder, corridor, and if this matter accordingly immediately after vacation. Okay, we are listing it immediately after vacation.
Published.
Item 2,
In my opinion, Your Lordship. Well, this petition is filed by the petitioner, Lordship, for a, if your direction.
Status of the case we have received already.
LCO called for, Lordship. Whether it is not reflected.
LCO
in-
was called for.
Yes. It is not reflected in the
Perhaps it
cause list. Perhaps it was not received.
But so far as my instruction, Lordship.
Why it is in motion column? In fact, it should be about to have been in
Yes,
order
Doesn't
column.
be
Wrongly.
Wrongly.
In the
Wrongly.
motion.
But Lordship.
Otherwise also we have not received scan copy.
Scan copy also.
Lordship, so far as
No.
my instruction, Lordship, that was already sent from the landed court below, Lordship. So that might be
Maybe-
kept in the office, Lordship. So,
Scan copy to LC.
Just we are seeing.
To register.
As per office note dated 6/12, LCR is awaited. But as per your instruction, if it has already been received, I don't know,
that was already sent from the landed court below, Lordship.
already sent.
Yes, Lordship. But perhaps there may be some, so date may kindly be fixed, Lordship, on reopening, Lordship. So that in the admission.
Hardly, and the scan copy of the LCR is not received. As full stop, as per office note dated 6/12/2022, LCR is still awaited. Issue reminder, next registry will take necessary steps. You want any fixed date here?
Yes, Lordship.
Fixed date is immediately after vacation. Fixed date, I cannot say.
8th, 9th, like that, Lordship, any date, Lordship. Otherwise, Lordship, it will not be listed, Lordship.
10th.
I'm authorized, Lordship.
And
3,
The picture before Lordship man is gynecologist. And he was a gynecologist working at a relevant point of time at Jaspur Mandal, in Nemcare Hospital, man. In Jaspur,
Tezpur Nemcare.
Nemcare. What happened in actually what a case was lost against him, my lord, by one of the patients, my lord, stating that the Lordship find an extra, it is page 26, my lord. Page 27, 28 is the FIR, madam. It says that with due respect, I like to state Srimati Dipali Boro, wife of Agun Ramsiari, resident so-and-so, is my daughter-in-law, where she was pregnant. She came to her residence at Mezanjali, Sonitpur. She was under treatment of Dr. Satyajit Banerjee, that's a petitioner, at Nirmala Polyclinic, ward number 6, near Sankadev Sishu Niketan, Dekiaji. For delivery and treatment, she was admitted in the said clinic on 5/9/2023, madam. And she was discharged on 7/9/2023, 17/9.
70.
Later, she felt severe abdominal pain, and on 25/6/2024, she was again visited Nirmala Clinic, consulted the same doctor. After preliminary investigation, but the same doctor advised her that she had a tumor, due to which she is facing some severe abdominal pain, and due to undergo a surgery. After that, I, along my son, took my daughter-in-law to Rovi Boro Civil Hospital at Mushalpur, Baksa. And therefore, she was admitted in the said hospital, underwent a second surgery. That outcome of the said surgery, revealed a surgical towel was found inside the abdomen, medical documents enclosed. Doctors advised Dr. So-and-so is negligent, so-and-so, and inside a surgical towel of my in-law doing the. So that is the FIR. And FIR was registered under section 3.
In under this doctor, what kind of surgery she went on? She delivery. I mean,
Delivery, according to her, she was
she was pregnant.
she
When
was
she was
pregnant.
admitted
So what kind of
for delivery of child, or it's not?
that has not been stated in the FIR. Only she stated on 15/9 I was admitted, I was discharged on 17/9. Later she fell severe pain and subsequently after nearly 8 months, 9 months, she visited and so I told him that there was some problem. She has to undergo surgery, my. And there in Rani Prabha, she has come to know, my lord, and Musalpur, that with the second surgery, my. Now my first question, because I'm already on bail, my. I'm already thinking that because there is a decision of Supreme Court. If you want to prosecute a doctor, my lord, then the Jackie Matthews case.
One report has to be there.
Yeah, yes, I'm just coming to that part, my lord.
Here, where is the order of cognizance?
No,
This
yes,
is Sarsi-
Sarsi has not been submitted.
Oh, sorry, Sarsi is not yet submitted.
Your lordship may kindly come to page 35 of the judgment. It is a three-judge judgment, my lord. But by Harsi Lahoti, my lord, justice. Page 35, my lord. Paragraph 51, my lord. We may not understood as holding of doctor cannot be prosecuted for offense with rashness or negligence, the essential ingredient. All that we are doing to emphasize the need of care and caution in the interest of service, where medical profession and as human beings is probably noblest of all, as there is need of protecting the doctor from frivolous and unjust prosecution. Many a complainant prefer to go recourse to the complaint process as a tool of pressurizing the medical professional for extracting uncalled for and unjust compensation. Such malicious proceeding have to be guarded against. Stated rules for executive instructions incorporating certain guidelines need to be framed and issued by the government of India or the state government in consultation with the medical council. So long it is not done, we propose to lay down the certain guidelines for future. This should govern the prosecution of doctors or offences which criminal rashness or negligence is the ingredient. A private complaint may not be entertained unless complaint has produced a prima facie evidence before the court in the form of a credible opinion given by another competent doctor to support the case of rashness or negligence on the
You
part of
see,
the.
here the question is that if the cognizance would have been taken or
I
charges would
understand.
have
Now,
been filed.
next part is important. Investigating officer, your lordship, that is what I am coming with, your lordship. Before proceeding as a doctor, accused of rash or negligent omission, obtain independent, competent medical opinion, effectively from a doctor in government service, qualified in that branch of medical practice, who can normally expect to give an impartial and unbiased opinion, applying the Bolam test of the facts collected in investigation. A doctor accused of rash may not be arrested in routine manner. So, my provision is that whether that procedure has been followed or not.
That's what I'm saying. Now,
Yes.
the question is that you have filed the petition
Yes.
before filing of the charge sheet or even before filing of, suppose, say, taking order of cognizance.
I understand, but now
So now, how can we say at this
that
stage
a
that
report may
whether
be-
there is any preparation for the investigating
no,
agency
so-
to obtain any medical report in
your
that
lordship,
regard?
direct the investigating officer or OC whether they have obtained any independent opinion in terms of the judgment of this honorable.
Well, at best, we can call for a case diary.
Case that yes, that
Yes,
can,
that
because
much we
that
can do.
is the requirement of law, man.
Yes, that is the requirement of the law at present, but the question is that they may be in that process, I don't know, because we are not in that age. It is a very
Yes, because
premature
that is a
stage.
requirement that has been complied with or not. And moreover, what has happened in this case, your lordship, I filed a case. They've extorted me rupees 5 lakhs. They demanded 30 lakhs. Earlier in point of time. That FIR also I have closed with your lordship.
So you have already paid money.
Yes, yeah, I was supposed to pay money, madam.
Why?
Because they have on gunpoint.
Why you have paid money?
On gunpoint, your lordship may kindly see my FIR, man. That was earlier in point of time. That was registered as that pays 21, my lord. To the Superior Police Sonipur, my lord. That is of on 10/8, suddenly at owner of Ninola called me to the relatives of persons. When I reached at the polyclinic, 6 unknown persons assembled there. And without any valid reason started targeting me. The surgical was left in the stomach and C-section of the so-and-so. And due to which she was serious and treatment GMC. For this unknown was statement without hearing me, giving me, unfortunately, only demanded 30 lakhs. And for me, forcibly made me to write in a piece of paper, took me signature giving 5 lakhs instantly. That was on 10/8. And thereafter they made a slab of payment of deposit next slot of 5 lakhs next week. Thereafter raised the amount is 30 lakhs. 5 lakhs in a month. Having no option, I was bound to hand over 5 lakhs in cash. After arranging different sources and same was received at Bhagirod Namsiari property. But now, after said payment, I inquired of the history of the payment. I found that in this report it was diagnosis of ovarian cyst. She was suffering from ovarian, not There was no surgical map in the EC report, ma'am, which I have collected, ma'am. So on false narrative, I was harassed,
The
ma'am.
doctor under which she gone the second operation,
Uh,
she undergone for the second operation, was there any enmity with you?
No, nothing, my lord.
Then why he will say that the towel was there?
I don't understand how they made it, but whatever it is there, it was found to be.
There may be cyst, ovarian cyst may be there, and she may suffer from pain and all. That's
That is
okay.
different, but there
That
was no
may be,
surgical
but-
map. That's why Supreme Court has said that
Obviously.
there's
that is
requirement independent investigation by a doctor or government doctor to find out whether any such criminal negligence has done or not. That is my submission.
Mr. P. Kotoki, the learned counsel for the petition, and also heard Ms. S.H. Boda, the learned additional PP appearing on behalf of state respondent. This is an corridor application, so and so. Sir, that's what issue notice corridor to the respondent number 2 to register AD and as usual process. No formal notice is required to be served on respondent number 1. However, the extra requisite copy may be served during the course of the day. Further, Mr. Kotoki submitted that it is to be submitted that before investigating the case or during the investigation of this case, it is the duty of the investigating officer to collect a medical report or a opinion from the medical board, which is comment doctors constituted by the comment doctors as per the guideline of Honorable Apex Court passed in case of Jacob Matthews, packet of super. Accordingly, next part, considering the submission made by Mr. Kotoki, let CDB call for accordingly. We will have to fix after vacation.
Case number 164.
Yes,
Of
it
the
will after CD
2020.
call koribo take as PS so and so. When it can be called for?
After due vacation. it is.
After due vacation,
23rd.
23rd of January. Otherwise, you were on bail.
I
think-
was on bail. I had surrendered before the court. I was on bail. It is bailable offense.
Oh.
Huh? I mean, it is-
23rd of January.
Item 4.
Huh?
Yes, Lordship. Lordship, this is a criminal petition, Lordship. Lordship, on the last occasion, your Lordship has asked for a certified copies, Lordship. We have already applied for the certified copies, but have not received yet, Lordship. We'll get the
Certificate copy of the order
order
sheet.
sheet. Till the Monday, we'll get the certified copies. Lordship.
Monday we cannot fix.
Lordship, NBW already has been issued against the petition.
What to say, what to do. Because we don't have plus with the cases. In fact, today also, most of the matters may be left over also. That is the position now we are having. It's not in a position, in fact, to call for any fix any takeout. 19 and 20 will be full of motion day. Has already been noticed, is already there.
Yes.
From 16 onwards, it will be a motion day, but still we are fixing some of the dates, the bail matters and all. Otherwise, rest other matters, we were trying to fix after the vacation only. We'll pass the order immediately after vacation.
Yes, Lordship.
If the registry, you can approach registry. If it can be fixed by 3rd or 4th, maybe in 7th or 6th, it will be okay.
6 January.
6 January.
Lordship.
You want to fix it, date,
No, if my learned friend wishes. Lordship.
date is 6th January, we are this week, that week too, we are
Yes,
full of
yes.
cases. In
As per
fact,
lawsuit's convenience.
and immediately after vacation, we list,
Yes, Lordship.
the registry may list accordingly.
Yes.
Okay. Heard your MS? Heard MS M. Deccan, the learned
Yeah.
counsel for the petition. Appearing on behalf of MS G.
G.
Bora. G. Bora. Also heard MS SH Bora, the learned additional PP, so and so. It is submitted by Ms. MS Deccan that though they have applied for the certificate copy, it is not yet furnished to them and accordingly prayed some more time to furnish the same. Prayer allowed, list the matter accordingly on 6th of January, you're saying. Oh, immediately after vacation, list accordingly immediately after vacation. Date to be fixed by the registry. Okay, immediately after vacation.
Item 5.
Yes.
This petition is filed for passing the FIR dated 12/8/2024 registered as Algapur Police Station, BPS case number 85 of 24, corresponding to the GR case number 611 of 2024, pending before the London Subjudicial Magistrate, Hailakandi, my lord. Well, the FIR is at page 13, my lord. This is the type copy. Content of the FIR, my lord. Content of first information report. District Highland and PS Algapur was FIR number 85, dated such and such. The on first information content on 12/8/2024 at 4 p.m. complainant Nazma Begum Borbuya lodged an FIR at his PS stating that her son-in-law Baharul Islam Laskar, accused number 1, and his mother Rina Laskar conspired with employees of the District Transport Office, Kamrup, to upload false information and create forged documents. Baharul Islam, who entrusted to the complainant's truck number such and such for maintenance, and this honestly transferred the vehicle to his mother's name. The accused used false documents and electronic signatures to effect the transfer of ownership, thereby violating the Information and Technology Act 2000. Upon discovery the transfer online, the complainant contacted the Hailakandi DTO office, which informed her that the transfer was invalid without her consent and presence. Hence this case. His FIR at page 18, my lord. His FIR. His FIR.
What FIR? Stays
FIR, page 18. It is the content of the FIR, and the FIR, original FIR, laws before the at page 18. This is a complainant Nazma Begum Borbuya against the petitioner number 1 and petitioner number 2. That the complainant submit
The
that.
the truck was in the name of the complainant informant.
Yes.
So it has already been transferred fraudulently
My
by
lord,
forging her
my lord,
signature and all.
It is a second hand truck, my lord. It was purchased deed at page 24.
But it was in the name, maybe second hand, I don't know, not on that.
But I have purchased, my lord. I have purchased. Deed is there, my lord.
You have purchased.
Yes.
Where is the deed?
24.
You have purchased from whom?
The Lal Rang Sengi. Lam Rang Sengi of Mizoram. It is a
You are a resident of,
resident
you
of,
are from
I am from Kamrup, my lord, now.
Kahipada, and you purchased the car from Mizoram.
Mizoram.
Yes.
My
Why?
lord.
Why you have
It
come
is
so far?
registered under the DTO Kamrup, my. It is a registered DTO. I have purchased. And according to this deed, after the purchase, he will transfer the vehicle, registered his name in the office of DTO as per the agreement.
So you are the registered owner.
Yes, I'm registered, but after the lodging of FIR, the petitioner was arrested. And the first day on producing the before the CJM, they released granted bail, my lord, at page 27.
It's okay, you are on bail now. The case is at the stage of investigation still,
Yes, my lord.
or charge sheet has already been filed.
No.
No charge sheet.
It is amply clear from the orders of the one CGM that mere allegation is not enough.
No, it's okay. Mere allegation is not real. We're calling for a case diary. In fact, you are on bail, I think.
Yes, my lord. Both are bail. Both are on bail. Murder also. They,
your son-in-law and mother. So why she brought all these allegations against you if you are the registered owner, if you have purchased it? Why?
my lord, I have purchased, I have
Yes,
paid
you
the
have
money.
purchased, you are the registered owner. then
Yes.
Why she?
My mother-in-law lost this affair because of
But she
some
said that,
differences.
but she said that it was transferred dishonestly. That means earlier it was registered in her name. That's why she is telling.
No, my lord. No, my lord. As per agreement, my lord.
In support of his argument, whether he has submitted any documents that he's a registered owner of that vehicle.
I have purchased from the.
Have you filed any document regarding your ownership or raised as you were the registered owner? RC you have filed here. RC was not in your name.
Yes, in my name, my lord.
No,
Petition
you have
number
not
one.
filed here.
Not filed here, my lord. I'll produce it in the next day.
It was a stolen vehicle.
No, my lord. It is registered in the
So let us call
DTO
for the
Kamrup,
case
my
diary
lord.
lodged at this
DTO
stage.
Kamrup, my lord.
Because as per our knowledge, most of the cars and all the stolen vehicles are from
Yes,
Mizoram,
we
Nagaland.
Purchased a
These are
stolen
the
vehicle, yes.
areas from where.
Originally registered under the DTO Kamrup, my lord, in Assam. It may not have. It is not happened, my lord.
Anyway, you Mr. Dattan,
Yes.
part Mr. A.K. Dattan, বাকিখিনি লিখি দিব। MSSH বৰা, this is an application, বাকি লিখিব। Only call for the case diary কৰি দিব। Immediately after vacation will do,
Yes.
immediately after vacation.
Paper calling for the GRK.
Calling for?
GRK. Okay.
No, you
For
are
the-
submitting the charge sheet is not yet filed.
Not filed.
So enter CD will come.
Yes.
GRKs in what purpose you need the GRKs?
GRK.
Now, why you need the GRKs?
My lord, I have to watch that also, my lord. My lord.
Criminal
all that-
proceeding.
of course.
That proceeding not yet initiated, I think,
Yes,
because
still-
it's still under investigation. That's
Yes.
why I'm saying. We call for the case diary if it is available, it is a you are the registered owner, so and so, that may be a case for quashing. After vacation.
Algapur case number 85 of the 2020.
Side of Algapur case, likha ase, Algapur case transfer. Call for the case diary. We calling for the case diary, it will be listed immediately after vacation. Let's see what is it.
Item 6.
Decision to লাগে, more than kind of.
Where
Yes.
is the lot?
State is formal party or not party,
That is not a party.
not a party.
It's a 125 proceeding matter.
Okay.
What happened? 125 proceeding matter way back in it was way back in 2014 matter. The petition was 125 proceeding was final order was passed.
2014.
14. And the second party, the petitioner was directed to pay 1,500 per month. Now, thereafter, my lord, she did not take any steps. And matter kept, and it was filed, my lord. So,
It was filed.
filed.
Acha.
Then only on 2023, my lord, a petition was filed, my lord, that you also will find at page 29, my lord. That is on by their case
Page 29.
29. Case they got put up today on the strength of the petition number 1513 by the petition under section 128, man. For execution of the final order dated 2010-2014. I've seen the petition and also heard the learned counsel for the petitioner. Learned counsel while instead petition has paid for execution of final order for payment so and so. And calculated the date of order is 1,59,000 till today. Petitioner takes steps, service of notice upon the for payment of metals.
Have you annexed the order of that where is the order of file? I mean, the case record was closed or filed.
That
Have you annexed the order?
file, I've got the mostly order sheet there with me. Let me check it up, my lord. That is on 22, my lord. Yes, this order I have not enclosed. This is order.
Page number 22.
No, yeah, I have not enclosed that order.
Oh, acha.
That your lordship can.
No, you are saying that the final order was passed in 2014
Yes, madam.
and thereafter she
She
remained
don't-
absent.
Yes, but that,
But from this order, we cannot see anything because here it is written that last many dates.
yes.
What
Many
was
days
that?
she was absent, my lord. So no steps was taken. Ultimately, it was filed, my lord.
Yeah, obviously.
So it was
That's why it
filed.
was filed.
Fine. Now, the 2023, my lord, she filed an application, my lord, that your lordship filed at 29/8/2023, my lord. She filed an application and there was, the petition was directed to take steps and for payment of maintenance. And accordingly, on 2023, my lord, and there was direction for payment and non-bailable warrant of basis. My question is that regarding the dues, we don't have any grievance, my lord. This is entitled. Now, the mode of recovery, that has been this non-bailable warrant of arrest without section 128 provided.
But 6/11 was one date, another date. 6/11. Then only 2012 came, or I don't know, because as per order dated 29/8/2023, the date fixed was 6/11/2023.
Yes, madam. But
6/11/23, what had happened in fact?
611 for report and payment.
Uh-huh.
Uh,
Yeah. not
That and he has taken, he was absent, steps was taken on his behalf, my lord. And since he failed to make payment, so they made a petition, my lord, made a prayer for that, for recovery of our warrant of arrest may be issued by.
It is just since the respondent has already availed more than sufficient numbers of opportunities for making payment.
Yeah.
This court is inclined to grant another adjournment. Petition so and so stands rejected.
Yeah, that was because, yes, I understand that. But now whether the magistrate, my lord, in excess of 128 CRPC, whether can has a power to issue a warrant of arrest. That is the question, my lord. Putting you before lordship because execution order doesn't say so, my lord. Because 125(3) says regarding recovery, warrant of arrest can be issued, my lord, in lieu of fine. That is there, my lord. But that is limitation is there 1 year. Because it was of 2014, my lord. And now it is 2023. This is more than 8 years, 9 years. So limitation goes by. So there he has to go for the 127, 128, my lord. 327 and 321, my lord, of the CRPC regarding recovery of fine. But warrant of arrest doesn't provide for warrant of arrest. That is my submission. So my prayer is that warrant of arrest may be stayed, my lord.
Then what will be the mode of recovery?
Mode of it-
327.
Yes, my lord. Naturally, my lord. Because 128 doesn't say so, my lord. Because then CRPC other provision will come, your lordship, then 320. Because levy of fine is it falls in chapter, your lordship will find chapter 22, my lord, 32, my lord.
Yeah, yesterday.
There he says, my lord. Section 431, my lord. Any money other than fine. Because if it is fine, then 125(3) will come. Any money other than fine by virtue of an order made under this code. And the method of recovery which otherwise not expressly provided. So because 128 is silent regarding recovery of provided shall be recovered as if it were a fine. And provided order section 14 in the application, fine means 421 will come. Provided section shall in the application and order under section 25 of the section if so and so, 420 words figures that is regarding 50, 57 regarding compensation part. So now that's why then 421 will come into play. Warrant to levy of fine. That is 421. So directly they cannot issue warrant of arrest. That is my submission to your lordship. Because 128 doesn't lay down the procedure of recovery. So we have to go by the procedure laid down on the CRPC. That is my submission to your lordship.
Yes, what is the other prayer from you? Then,
And because 125(3) says that there are incidents also, 125(3) for mini limitation. That this is another mode of execution, that by way of sentencing for 1 month or other. But that is not a satisfaction of the order, of the decree or whatever it is. So that payment he has to pay. So warrant of arrest will come only in case of 125(3), not in 128. That is my submission to your lordship. Because here it is, admittedly, he has exercised the power, the Lorry Trial Court has exercised the power under section 128. And 128 is very silent, regarding the procedure adopted for recovery of the amount. So they cannot recourse to 125(3), since it is a fiction under section 128. That is my submission. So then provisions of section 431 comes into play.
that you may make payment then.
Yeah, naturally I will make payment. But that my submission is warrant of arrest cannot be issued. Compelling me to make payment.
By Mr. P. Kotoki, the learned counsel for the petitioner. This is an application under 528 BNSS for setting aside and quashing of the entry agreement proceeding under section 125 CRPC. And on the order dated 29/8/2023, whereby the learned GMFC Bongaigaon had issued NBWA against the present petitioner in case number in MCR case number 42 of 2012. Issue notice to the the sole respondent to registered alien as usual process. And also call for the scan copy of the LCF poster. Next paragraph, Mr. Kotoki further submitted that the warrant of warrant of arrest. No, the case was the final order of maintenance was passed in the year 2014, but thereafter the respondent remained absent, and accordingly considering her absence, case was filed by the learned trial court below, wide order dated 20. (29/08/2023). Oh no, sorry. Dated 25/02/2022. And thereafter only on 29/8/2023. And the respondent filed a petition under section 128 CRPC for enforcement for execution of the final order dated 2010/2014, and also claim for the area maintenance. But on height order dated 2012/2023, the learned court below had issued the NBWA against the present petitioner, which is not tenable under the eye of law, as the petition was filed only under section 128 CRPC, where there is no such provision of recovery by issuing NBWA, and hence the resort to section 431 CRPC has to be applied for. However, he submitted that he is ready and willing to file, ready to pay the maintenance allowance as filled by the learned trial court below, and prayed for stay of the execution of NBWA issued against him. First, considering the prayer made by Mr. Kotoki, the learned counsel for the petitioner, let the NBWA issued against the present petitioner be stayed or suspended till next date of listing, list according after 4 days. Need to get happen.
47th.
May I please, Lordship? Lordship, here is a company which was formed for the purpose of manufacturing of food product, my lord. Now, during COVID period, my lord, what happened, my lord, the company has sustained huge financial loss. Out of which certain creditors who has supposed supplied the materials, they are demanding the money. Therefore, Lordship, there is a provision under Insolvency Bankruptcy Code 2016, a liquidated company which is not possible to attend the liability of the creditors, they can approach to the NCLT. Now, this company approached before the NCLT. Now, while approaching before the NCLT under this IBC Code 2016, this petition was accepted, including the parties which are liable to be supposed to be paid by the company, that has also been taken care of. Now, after considering all material fact, attending the parties in before the NCLT, the final decision was adopted by the NCLT was that the company is fit for liquidation because it is not in a position to attend the liability of the creditors. Now, having such a position, Lordship, this decision was adopted on by the NCLT, that is 12/1/2024. Now, there is a specific provision laid down under this IBC Code 2016 under Section 14 that while this proceeding has been initiated before the NCLT, then the all proceeding, that is including civil or criminal, whatever in nature against the company, that has to be kept in moratorium period till the completion of the entire proceeding. Now, since this company also had the liability of one of the complainant who has filed an FIR, which was also the party of the NCLT, my lord, the person to that, my lord, a criminal case was filed, thereafter charge sheet was also submitted. Now, while the charge sheet was submitted, we approached before the learned trial court below, stating inter alia that since the NCLT already taken care of this entire issue, and out of which moratorium period is already there, under which this proceeding is not liable to be maintainable. But the learned court below, without looking into that aspect in a meticulous manner, straightway come to the conclusion that since there is no need direction from the NCLT for staying, therefore, my petition was rejected. Hence, Your Lordship, at present, I am before Your Lordship with revision petition. Straightway, I am coming to the part of NCLT order. Lordship, just have a look for a moment, page 56. This is the NCLT order, page 56, start from 2022. Page 56. Now, Lordship, the complainant is Synchro Park. That is in Lordship from down second line. From down second line. Now, Lordship, pursuant to that, this decision was adopted and final conclusion in page 66. 66, paragraph 7. Page 66. Now, page 66, paragraph 7, this statement is this follow. Accordingly, this bench admit this above CB number under section 10 by passing the following order. There shall be a moratorium under section 14 of the IBC regarding the following: the institution of suits or continuance of the pending suit or proceeding and the corporate debtor, including execution of any judgment, decree, or order in any court of law, tribunal, or other authority that has been kept as a under moratorium. The line is very much clear, moratorium part is there. Now, based on that, Lordship, we approached before the learned court below, and this petition was entertained by the learned court below that contained in page 69. Page 69 order passed by the learned court below. Accused persons are absent. We registered in fight petition number having sole cause of absence, which is allowed by extent petition. The learned counsel for the accused person have stated that the accused person approached the honorable NCLT under section 10 of the Insolvency and Bankruptcy Code 2016 for initiation of corporate insolvency resolution process, and the honorable NCLT, after hearing all the parties at length, was pleased to admit the petition of the accused person by order dated 12/4/2024. Directing intent that there shall be moratorium regarding the institution of suit of the continuance of the pending suit or proceeding against the corporate debtors. The present accused person, including execution of judgment, decree, along with the petition copy of the order passed by the has been enclosed. Now, this has been taken care of. Now, the order which now under review that contained in page 71. Last paragraph. Page 71. From down, second paragraph. Also seen the certified copy. Also seen the certified copy of the order date 12/1/2024 passed by the learned by the National Company Law Tribunal. Learned counsel for the accused person prayed for stay of this case in view of the order dated 12/1/2024 by the National Company Law Tribunal, There is no any specific stay order by any superior court for state, hence therefore stay is rejected. Now, Lordship, the NCLT already clearly mentioned that all the proceeding, whatever in nature, that has to be stayed under moratorium period. Now, this perception clearly shows that the paragraph which is indicated in paragraph 7 of the order has not been properly dealt with. Apart from Lordship, my second ground of submission is that it is purely a case of civil in nature, out of which no cognizance can be taken care of. Lordship, kindly see for a moment the FIR. FIR in page 20, madam, 20. This is the second line of submission, madam. Page 20. Madam. This is the part of the FIR. With due respect to the sensitivity of our office, therefore, I, Sanjeev Morgan, being proprietor of the Synchro Park, a proprietor firm having its factory, Kachari, so and so, back to state as follows, that on about July 3, 2021, I received an order on WhatsApp from Saurabh Goenka, principal office, so and so, having their registered office at so and so, to supply PVC trays and paper trays at amounting to 1,99,184. We have raised an invoice so and so to that effect purely on verbal assurance. We have delivered the material with a hope and expectation that you will make the payment immediately. Unfortunately, it is a matter of disgraceful on their part that despite of our several reminders, both in writing and otherwise, they did not pay a single paisa, not any response from their end. In view of the above facts and circumstances, I humbly request you to treat this complaint as a first information and investigate the same according to the Lordship, Contract Act clearly says that in case of breach, my lord, of the conditions, my lord, criminal liability cannot be invited, my lord. If this is so, my lord, then each and every transaction which is defaulted by the other side, my lord, that invite criminal case, my lord. The my lord, Oil India case is very much clear. The nature of case, prima facie, so my lord, civil in nature, my lord. Then my it doesn't attract, my lord, criminal liability, my lord. FIR, my lord, the whole purpose is to create a my lord, pressure from the police, my lord, so that the amount can be recovered for indirect way, my lord. My lord, in this, my lord, circumstance, there are two legal points are there, my lord. That while a NCLT has passed an order where that is the statutory provision of law, section 14 says about that part, my lord, that the all proceedings are to be kept in abeyance, my lord, till completion of liquidation. Now, suppose simultaneously whether a proceeding can be live or not, my lord. This is the one legal issue. Second legal issue is that, my lord, a FIR clearly, my lord, discernible from the facts that the transaction which has been made between the party, only my allegation is that I default to pay, my lord. Does it attract criminal liability 406, 420, my lord, etc., my lord? This is the second limb of submission, my lord. But these are the two legal points which require further consideration at this point, my lord, because the next date is 17, my lord. Therefore, my lord, if proceeding will go ahead, my lord, then nothing survive in this case, my lord. My prayer, my prayer is that, my lord, notice may issue to the, my lord, concerned party till that, my lord, the proceeding can be stayed, my lord.
Yes, Bora, Daniel.
Lordship, since the matter has been seated and cognizance has been taken, Lordship, at this stage, I'm just praying for the issuance of notice on.
My
They
prayer is
can
that,
appear, Lordship, thereafter.
Lordship, my prayer is that, Lordship, kindly see for a moment. Some disputed facts are there, Lordship, other side, my lord, definitely attendance is required, no doubt. But this judicial order directly says that in terms of, my lord, section 14, all proceedings are to be kept in under moratorium period, my lord. Now, can it be bypassed by the trial court, my lord? If this is so, my lord, it creates a situation of indiscipline, my lord. It ultimately a case of breach of the judicial order, my lord, which, my lord, I think not a good, my lord, precedent for anyone else, my lord. Now, other side may come, they may argue their point, legal point, that whether in existence of the judicial order, whether proceeding can go or not, is a legal issue, my lord. But prima facie, my lord, because, my lord, at the motion stage, my lord, kindly see. And second, Lordship, FIR. It is discernible from the FIR itself, my lord, that only my liability that I failed to pay. That's why, not a single word, my lord. Dishonest intention, fraud, nothing is there, my lord. Lordship, can you take care of that? If suppose this practice will follow, my lord, anybody will go file an FIR, my lord, then nothing will survive, my lord, in respect of NCLT order, my lord. That's why, my lord, I'm saying that this prima facie is a good case, my lord. Proceeding may kindly be stayed, my lord.
Mr. H. Amaria, the learned counsel for the petitioner, and also heard Ms. S.H. Bora, the learned additional PP, appearing on behalf of item number 7. So and so. Okay, this is an application filed under section 528, so and so. For the criminal proceeding asset. So and so. Pending before the learned Kamrup, so and so. issue notice to the respondent number 2 to registered AD, and as usual process, no comment notice is required to be served, so and so. Requisite copy of the petition may be served during the course of the day. Mr. Samalia further submitted that an FIR was lodged against the present. You are a farm, no?
Yes, ma'am.
But is your name is
Tigro Park, ma'am. Property farm, and that owned by this is
is
Sanjeev
not
Kumar.
here. Huh? No, he is Sanjeev Madani, but you are Bikash Goenka.
Yes, yes. I'm the director of the company.
Director of the which company? It's not
My
clear.
lord, I'm the director of the company of this, my lord, Vishal.
Hmm?
I'm the director of, my lord, the concerned company, my lord. PL
Which
Industries.
company, huh?
PL Industries.
PL.
PL Industries, my lord. My lord, that containing page 42, my lord. The application which I have filed. There are 3 directors. My lord, that FIR contains the name of PL Industries.
No, I don't know. Up to your name. PL Industries, PL. Submitted that the petitioner is the director of the PL Industries, and the process of liquidation is also already pending before the NCLT. And as per section 14 of the Act,
IBC code.
IBC code
2016.
2016, no?
Right.
2016. Your order is page 66, no?
My lord, 66. Direction is specific.
So I said there was a direction that there shall be a moratorium under section 41 of the IBC, and wherein the all proceedings all proceeding suits, criminal proceedings, including execution of any judgment, decree, order, etc., will be under the period of moratorium till the process of liquidation is over. In view of this, the petitioner also approached before the learned trial court below with a petition. But for your prayer work for?
Pardon?
You filed a petition, prayer work,
Therefore, my lord, staying the further proceeding.
stay of the further proceeding.
Basically.
But without considering this aspect of the case, that petition was rejected and case is proceeding further. In view of this, it is submitted that unless there is a stay order in the proceeding, the entire purpose of filing the present petition will become infructuous. Full stop. Considering the prayer of considering the submission made by the learned counsel for the petitioner, let the further proceeding pending before the learned CGM Kamrup M Guwahati in PRC case number 2-333-2023, registered under section 406-420-34 IPC, be state till next date of listing. Therefore, submission, our submission divo agot holo. Mr. Samaria further submitted that the entire dispute is arise out of an agreement, contract agreement, and hence the cases of civil nature and no criminal liability rest upon the petitions. That I mean, sorry. Okay, first.
Deeply.
Call for the LCR for it. Scan copy. of the
But-
Made.
Yes, yes.
Washing of the affair.
Hmm.
And the subsequent search sheet as well as the proceeding. Yes, 18-year lordship, kindly have a look here.
Just
This is the,
a second. It is a 6 of POXO.
yes,
Then will issue notice only and will call for the scan. Is a charge sheeted matter?
search sheeted matter, but 113 is the Lordship, 113 is the next date, your lordship.
Huh?
113 is the next.
13-12.
13-12.
13-12 is next days for fixing for what?
Prediction, your lordship.
Okay, then
Adjournment.
you take adjournment somehow, or you may appear, you are on already on bail or not?
No, no. Charge was submitted showing me as a.
Absconder. So take adjournment somehow, because it is a case section 6 property POCSO, we cannot
But
pass
he-
any order on stay.
But herein,
With
your
any
lordship,
condition.
that means. Herein, that means the main fact is that your lordship, as per definition. Either parties, that means herein. So far, the definition of the child means in case of a male. Who has not completed the age of 21 years. And in case of female who has not completed 18 years of age. But on the day of marriage, your lordship, the victim was 18 years, 11 days, your lordship.
That is your submission, that
Yes,
is
ma'am.
your plea.
Yes, yes.
That's why I'm saying. Because just calling. Call for means it's already charged, I think. Yes. Yes. Heard Mr. A.M. Khan, the learned counsel for so and so, and also heard Ms. S.H. Bora, so and so. This is an application, section 528, so and so. Issue notice to the respondent number 2 through registered AD and as usual process. Just a second, it is a case of POCSO, whether through that process it has to
Yes,
go.
yes, same process. As
Hit
mandated
process
by
of right.
notification 17.
Through jurisdiction minister routed to the office of the registry and the public prosecutor. I also call for the scanned copy of the LCR. Maybe otherwise we have to list it after 4 weeks, but as your case is there, so let it be immediately after vacation. We are not going to fix the date immediately after vacation.
1/6, your lordship.
Yeah. Pardon?
6 January, your lordship.
No, sorry.
Immediately after vacation means, your lordship, then.
No, we are not, we
Again?
cannot fix it there because the question is that we have already fixed date is there. Entire week, in fact, from 3rd to 10th. That's why we're not in a position to fix the date. If raised is says that there can be a odd date, then we can immediately after.
Item 9,
Yes, 9. Mm.
The case is that lordship, their lordship cognizance was taken on 22nd 5/2018 lordship.
Cognizance was taken.
Lordship. After the lordship petition.
You were earlier on bail or no?
No,
Earlier you were on bail.
No, lordship, after cognizance was taken, it is in.
Oh, NI case.
Yes, lordship.
Acha. Then what had happened?
Lordship on page number 34, lordship, order dated 21st/10/2019, petitioner appeared before the concerned court and filed bail application.
21-10.
Yes, lordship, page number 34.
Bail petition was there. You are allowed to go on bail. Then
Lordship, your order was absent. As far as adjournment petition, please engage counsel, lordship. After the lordship on February, lordship, his father, February of 2020, lordship, his father had expired. Because of that, lordship, on February, March, he couldn't appear in the court, lordship.
when father expired?
Lordship, on 7th February 2020, lordship.
2020.
Yes, lordship. But here, we've engaged counsel filed adjournment petition, lordship, which is also reflected in page number 38, lordship, order dated 27/2/2020.
So that day also your petition allowed.
Subsequently, thereafter, lordship, COVID-19 pandemic and lockdown, due to all those things, there was court proceedings were disrupted, there was no fully court functioning. Subsequently, when they resumed lordship, although it resumed somewhere around from 1st of 2021 lordship, page number 42. Since the petitioner was suffering still from illness, lordship,
he couldn't appear, but still he had to engage counsel file adjournment petition lordship, but on page number 43 lordship, 19/2/2021, Leonard Trial Court issued bailable warrant against him.
Hmm.
But after that lordship on again February 28, 2022 lordship, subsequently he was issued non-bailable warrant lordship. Page number 47 lordship is the first non-bailable warrant. Petitioner was actually lordship suffering from illness and COVID effects on chronic appeal lordship, but due to his engaged counsel had filed adjournment petitions lordship on regular basis. But Leonard Court on 28 February 2022 issued non-bailable warrant, and subsequently warrants have been issued one after the other lordship. Recent is we have annexed is on page number 58 lordship, 2/8/2024. But then actually, this time will appear for the court lordship. All lordship can allow till the next day lordship. Next day is on 13th to 12th lordship. Suspend the warrant till next day lordship.
Yes, and his absence is now set to resolve 2018, I guess. Obviously, he was on bail and steps were taken on behalf of him also.
Yes.
Mr. A.
Injection.
Anjet. Anjet Choudhury. ফলে মেসেজ করা বাকিখানি ইস্যু নোটিস করবো না Mr. Choudhury, the learned counsel for the petition submitted that the after taking cognizance by the learned trial court below, he appeared before the learned CGM so and so, and he was allowed to go on bail on 21/10/2009. File order dated 21/10/2019. But thereafter, for some days, he could not appear before the learned trial court below, as his father got expired on 7/02/2020. Thereafter also, the learned counsel for the petitioner appeared before the learned trial court below and filed petition on his behalf. But thereafter, as the lockdown started, as there was lockdown due to COVID pandemic, the court work was not functioning. However, after regularization of after functioning of the court work, the learned engaged counsel also filed a petition on his behalf, which was also allowed. But finally, the learned trial court below issued BWA against him. Due to he could not appear on various reasons, and also for his illness, and subsequently, by order dated 28/2/2022, the learned trial court below had issued the NBWA against him and on the other subsequent dates. Mr. Choudhury further submitted that the petitioner is still ready and willing to appear before the learned trial court below and to contest the case, appearing on each and every date fixed by the learned trial court below. If he is provided with some interim protection. In this context, Ms. Ashit Bora, the learned additional PP, submitted that the accused petitioner remained absent for a considerable period. However, he may be directed to appear before the learned trial court below with an appropriate application for bail. which may be considered in accordance with law. Next para, hearing the submission made by so and so, considering so and so, allow till your this is fixed on 13th.
13th Lordship.
Till next date of listing, 13/12/2023, the NBWA issued against so and so be stayed or be suspended. Till 13/12, we are suspended.
Whether PNA has been issued.
PNA already issued.
Because whether it is issued, because after 6/8/2024, no order has been annexed.
Lordship. 10 orders we have not been able to annex Lordship.
That is not annexed.
Already as per our information, still non-bearable warrant have been issued Lordship.
PNA is not yet issued. PNA may not be there also because other reports doesn't say so that.
Yes. So up to 6/8/2024, the order set is here. Thereafter, the 3 months, what will happen, we do not know.
তেতিয়াহ'লে এটা submission তেওঁৰ পৰা দি দিয়ক এটা ফালৰ পৰা Learned counsel for the respondent further submitted that though he could not annex the up-to-date order, but as per instructions from his client, the learned trial court below is still issuing the NBWA against his sweats.
Okay.
Lordship, similar type of item 11 also Lordship.
Same frame. 11.
Yes, Lordship.
The dates are different, I think.
Yes, Lordship, here we are challenging NBWA. The recent way the next is 6/8/24,
6/8/24. Where is the order?
page 39, Lordship.
20?
39, Lordship.
39. Only that day the NBW was issued.
Here also it has been issued since page number 39, Lordship, 29/2023.
39 or 29?
29, Lordship, 20 September 2023, page number 37.
(2009) your BW was issued. Oh, it returned unexecuted. Date kita change করে দিব 20/09/2023 NBW issued as বাকি লিখো as the BW return unexecuted. Out of subsequent dates of NBW issued. Here also you were on bail.
Here we are not on bail.
Huh?
This petition we are not on bail, Lordship.
Ah.
May last 10 days time will appear because here next.
So where, what is the case here? It is, you are not on bail.
No, not on bail, Lordship. But similar type of occasion, Lordship, multiple complaints were lodged against him.
So
Here before the
Yeah,
case
was
is
there.
the Lordship, here cognizance was taken on page number, Lordship, it is in page number 30, Lordship. Here also we have appeared, Lordship, and
that Kataman date লিখক 19/12/2019 cognizance taken, summon issued, return unserved.
7/4/21. 11 to be followed.
তাৰপিছৰ পৰা summon issue হৈ আছে
It's taking some way.
11.
Lordship, non-bailable warrant of arrest has been issued
no, Lordship,
since
actually.
7/4/2021.
Lordship,
Item 11.
7/4 or 20? Not 7/4, I think 20/09. See, 20/09.
So Lordship is now taking 11 and he's talking about 9. Item number.
No, Lordship, I'm talking about 11 only. 9 was a different, Lordship.
Yes. Item 11. So 11 is 1503.
1505.
In our case, it is 1505.
Yes. Lordship.
You are talking 1503.
That is item 9.
Huh?
1505 is item 11.
Huh.
Item 9, Lordship already passed the order, Lordship.
Yes.
Now he is 1505.
Fine,
Yes.
Lordship. That has happened, Lordship, actually a couple of days back also we moved application, Lordship, multiple complaint petitions were filed questioning for NBW. So London prosecution office somehow misplaced the petitions, Lordship. So Learned Friend brought up questioning for different complaint petition, Lordship.
No, she is talking about 1505 only.
No, that is in item 11, Lordship.
Huh?
That is in item 11, yes.
Yes, you are on item 11,
Yes.
isn't it? Then?
Initially, she brought a different petition. That is why I had corrected her. Lordship.
Oh, yes, yes.
Count please, 32 of item 11.
Yes,
2021, Lordship.
74. No, it is different. I think your record is different.
Designation.
আমারটা দেখাই দিও। As per your, this one is on 7/4, cognizance was taken.
No, Lordship.
Designation is different.
Lordship, if my Lordship may allow me, Lordship, what is happening is
Item 11.
And 1505.
Lordship, my learned, the petition which my learned friend is producing, that is for questioning of a different complaint petition. Lordship, may kindly peruse the, Lordship, may kindly peruse the index, Lordship, first.
No, we are not going to peruse the index. Why is this presentation is not correct? Your petition is
No,
not
Lordship,
correct.
Pagination is learned friend brought,
Not telling.
Lordship, actually, we have filed for questioning of umbrella
আনমনে
warrant
বুজা
against-
বুজাবুজি কৰি থাকিব আৰু। List piece orbited or list code. List after vacation code. 11. We don't have time, such time to create all this.
December 11, to item 1505, this is
After the submission করি, yes. 10 করি।
Item 10.
সন্ধ্যাবেলা ফোন নিয়ে আসি মানডে।
And 06/8/2024, which was registered as to go report case case number 230 of 2024. In this matter, this after also we find it type copy at page 18, induced to commit suicide. In this matter, the petition number 1 is the brother-in-law of the deceased. 2 is the housemaid. Petition number 3 is the father of the deceased, and 4 is the sister of the deceased. They have preferred one bail application, which was allowed by this honorable court. Now, Lordship may kindly come to page 18. The type copy of the FIR. The FIR was lost by the deceased wife.
Who died in fact?
Page 20. Died. Died is one. The son of petition number 3, Manu Roy, was a security guard. This is further is petition number 3. 4 is the sister, and 1 is the brother-in-law of the deceased, and 2 is the housemaid. But in place of occurrence, nobody was present, and they were in a different dwelling house. The accident took place in the place of occurrence. Only complainant, the wife was present. That's our case. Before this, no. I think there's some in workplace, some pictures were taken and that was uploaded in the social media. That helps the deceased and he committed suicide voluntarily. That is as per information provided. Because only after was lost, it is under investigation. This so Also, they are on bail. Problem.
All for the case diary. State is the only respondent. Officer in charge, you have as a designation or what? Number 4, respondent number 4
Respondent number 4,
is officer in charge Gauripur.
officer in charge of Gauripur
You
Police
can
Station.
represent, I think, 1 and 4. State represent for 1 and 4. No formal notice is required. 2 and 3 notice for you.
Designation to
And also call for the case diary. You all are on bail, I think.
all on bail. Granted by this honorable court.
Gauripur PS case number 230/2020. যেটা আছে গৌরীপুর PS case number সিডি কল করে দিব খালি কাট করে দিব নাম টু সাইলেন্ট after petition. We're calling for the case diary and issue notice to the respondents. And case diary is called for immediately after vacation, it will be fixed.
We'll take steps
Yeah.
according to the order of the court. Deeply applied.
Item 12.
Concept 4528 petition lordship. In this case, petitioner challenged the quashing of the Ezahar charge sheet and the lordship entire proceeding lordship. Lordship, kindly have a look at annexure 1 page 13 is the Ezahar filed by divorced wife of the petitioner lordship.
Divorce wife?
Lordship. That is lordship annexure 1 page 13 with the allegation that there is a kidnapping, rape. Lordship, charge sheet submitted under section Lordship 366, 372, 511, 34. Lordship, kindly have a look at annexure 3 page 31. Learned court below issued summons to the petitioner. Page 31 annexure 3. They are reflected this penal provision 366, 37, 511, 34. Lordship, your lordship then kindly come to annexure 4, page 32 and 33. Lordship, out of grudge, she is the divorced wife, lordship, out of grudge lost the Ezahar. Now she is not over. Now she is not wanted to proceed with the case, lordship. And affidavit on, lordship, I have also make her a party. Let notice go and proceeding may be stayed. Lordship, kindly have a look at the page 33, affidavit shown by the informant.
Let's just tell us, she can put her signature.
Lordship.
Then why in FIR she only put her thumb impression? Because in FIR we see her thumb impression.
Lordship, that will reveal.
Huh?
She appeared before this alarming court, lordship. That will reveal.
Who will identify her?
Lordship.
Counsel?
That notice here. And her counsel.
Obviously, because she is a thumb.
But I am not aware.
You see in this, yes, then.
It's a non-compoundable offense, lordship. Is to notice.
No, notice.
LCR may be called for, let them appear, lordship, thereafter.
Lordship, proceeding may be stayed.
Not every state.
Can be.
376 is not there, Lordship. Charge sheet submitted only under section 366, Lordship. But if there is a compromise in that event, Honorable Court can quash, Lordship. I'm not saying that it is a compoundable offense. Then,
Where date is fixed, when date is fixed? Next date?
Lordship,
What a break, Lord.
31st, Lordship,
31st of
January.
January.
This, Lordship, December.
31st of December.
December.
I don't know, Ms. Bora, if it is supposed compromise, that may be, his submission may be true. He will appear, he will issuing notice. If it is already compromised, then stay maybe they are up to 31st of
Lordship.
next date of listing. Next date of listing, stay with you. Submission khali atai dibo, matter has already been compromised. And in that context, she already sworn an affidavit. Issue notice kori dibo baki khini and stay till next date of listing. List immediately after vacation.
All right.
How many? If there is no. Five. Now, A. Rahman and T. Hussain. Otherwise, what is the position? Is a case record we have received already.
My lord, LCR received, but it is not complete, my lord. Because as per the LCR, my lord, 6 witnesses have been examined, my lord, by the prosecution.
How many?
6.
Huh.
Now only, my lord, deposition of PW 5 and 6 are available in the, my lord, LCR. my lord.
Other
Available.
is a case of what?
NDPS, my lord.
NDPS.
NDPS commercial quantity. Let the petitioner appear, my lord.
We for some timing it will
No,
take
let it be, my lord, some other day, my lord.
some other day, or you want to fix it time being for time being?
My lord, that I limited also.
People. After vacation. In regards to period of detention, what is the incarceration period of detention?
My lord, that we have to look into, my lord, when the, my lord, PWs are examined, my lord. Because these are not available, my lord. When the charge was framed, when the PW 1 and 2, 3, 4 were examined.
Only evidence of 5 and 6 are
5 and
available.
6 are available. This is forwarded, my lord.
What kind of thing this? Why this incomplete scan
Okay,
copy has
madam.
been?
I have not checked before sending it to my registry.
27, 28, if the learned counsel for the petitioner, petitioner absent on call. Heard Mr. R.J. Borba, the learned additional PP, appearing on behalf of state respondent. It is submitted that though the scan copy of the LCR has been received, but except the evidence of PW 5 and 6, the other the evidence of other PWs, as well as the
Order framing, sir.
orders which are also not completed, is not also complete accordingly. The registry is ever directed to issue reminder and to call for a scan copy, updated scan copy of the case record. Annexed with all the evidences of all the PWs and the orders, complete order sheets. List accordingly after vacation.
Fifty-one of the elementary list.
My lord,
Yes.
the petitioner before your lordship is admittedly a blood cancer patient. There are reports in that regard, my lord.
Hmm.
And therefore, my lord, there is every likelihood that he probably won't survive the trial. So, my lord, because the medical reports and whatever instruction I have also filed an additional affidavit. While he was in jail, he fainted twice. He was admitted to Guwahati Medical College, not getting proper treatment also. Only on the ground of because nothing was recovered from his possession also, but I'm not going into merit. It is too early to go into the merit of the case. But the fact remains, my lord, it is an admitted position of fact. There are reports from the jail authorities testifying that he is a patient of blood cancer, my lord. So if that can be considered, my lord, because on the last two occasions also the court has called for the reports and court have perused the report also. And then probably another further report was called for, my lord, because the situation is deteriorating day by day, my lord. At any point of time, my lord, this case will have to abate, my lord, because of this.
You have filed your additional?
Affidavit also I have filed, my lord, it is there on record. In fact, this plea was taken in the bail application, and then subsequently when his health condition deteriorated, he was required to take blood, my lord. Page 26, my lord, will see of that. Nowadays, my lord, additional affidavit are running pages they are giving. So page 26 running page will do, my lord.
Page 26.
Page 26 running page. This is after filing of the bail application, while all this are given. Even an interim bail for 3 months will also, my lord, give some respite to this man, my lord. Otherwise, page 26, my lord, he's taking blood. It is in Guwahati Medical College. It is an admitted fact that he is a patient of blood cancer. He can only face trial if he is alive, my lord. That's the issue.
Yes.
Lordship, present health status report not received, Lordship. And Lordship, charge is submitted on 4/12/24. And DPS case number is 4/12, Lordship, 4/12/24.
CS.
Yes, Lordship.
Hmm.
And health status, present health status report is necessary, Lordship.
It
my
was
lord.
not called for. It was not
My
said.
lord, it was called for, my lord. She's confused a bit, my lord. I'll explain the thing. When this petition was moved, my lord, a report was called from the jail authorities. It is there on the record, my lord. The jail authorities have said that yes, he is a patient of this, what do you say in medical term, leukemia. There is blood cancer. There is a report, my lord, from the jail authorities. Then subsequently, some other reports were called for, my lord. In the meantime, his health condition got further deteriorated. I filed an additional affidavit, bringing on record, my lord, this medical prescriptions, photographs, and all this while he was taking treatment in GMC. Again, now he is in jail, my lord. Maybe, my lord, even for 4 or 5, because my lord, trial will take time, my lord, with the whatever little experience we have with the NCB, my lord. We have seen trial never ends up before 3.5 to 4 years. Earliest 3.5 years.
Lordship, he is a blood cancer patient since 2023 and he was arrested on 10/6/24, Lordship. He knows he's a patient, cancer patient. Still, he is involved, Lordship.
So they want
He
him to
committed
die. So their submission is literally that they want him to die. There has to be some compassion shown towards somebody, my lord. Aryan Khan got bail in 26 days versus NCB. There also the NCB was there, Aryan Khan. 26 days granted bail by the Bombay High Court. They never challenged those orders before the Supreme Court. Now for these people who are, my lord, hand to mouth sort of people, my lord, suffering from blood cancer, coming up with all those objections. Today morning only I was reading that Aryan Khan judgment. It is their own department, never challenged.
Lordship, commercial quantity, Lordship. Only 3 accused persons are there, Lordship. He was going to receive the contraband, Lordship. He was going to receive the contraband from the Lordship, courier, Lordship, courier.
My lord, if she is arguing on merit, my lord, then I must say, my lord, nothing was recovered from his possession. Section 67 is hit by Tufan Singh. Now, whether he was going or coming, my lord, those are tribal issues, my lord, will be decided in the trial. But as a human being, my lord, He's a cancer patient. At least he should have some protection, my lord. Only that much, my lord. Family members are also eagerly wants him to at least get the treatment.
Yes, any other submission from your side? Now, he is not on merit. He is saying that he is not on merit. The only aspect is that he is a cancer patient. That much only. But being a cancer patient, he wants the bail in that conditions exclusively on the health or medical ground. And otherwise, what is your submission? It is
So interim protection, interim bail may be granted.
for 3 months, interim bill can be granted. For 3 months, let it be.
Yes, my lord. At least he should have the treatment. If he's all right, then again he will go. And if the situation different, it is in their interest also that he should be alive for the prosecution. If he dies, the very purpose will fall. I'm deeply obliged, my lord. At least the council has accommodated that much.
This is your objection you have already filed. Na?
Yes, Lordship.
Now, undoubtedly, commercial quantity is there, and very recently the charge sheet is filed only on 4/11, 4/12, sorry, 4/12. That is understood. So you are also relying on some decision.
Judgment, my lord, where Bombay High Court has given interim bail on same blood cancer patient, my lord. There's a cancer case, Bombay High Court. Huh? Bombay High Court. Bombay High Court. There's a liver accident cancer patient. Yeah, that is 2023 SCC online Delhi 3270. This is one judgment, my lord. The other, there are few judgments, my lord, where the courts, my lord, in such circumstances have. Oh, yes, one judgment from our own High Court, my lord. That is bail application 1019/2023. Cancer patient. Marking for us. But in fact, on the last occasion, I have given all those judgments, even highlighting those parts, my lord.
Mr. S. MC Biswas. M. Biswas, the learned counsel for the petition. I also heard MS M. Deka, the learned counsel appearing on behalf of Mr. S. C. Kyle, the standing counsel of NCP. This is an application, so and so. But it was fit for present health status report, I think. It has not yet received, no? Is it received or no? Not yet. A report from substance and letter has been received on 21. Yes, it is as report has been received. Flagging. This is flagging. Report not yet received a short some more time to constitute the medical board and the to present health status report so and so. So, transcript,
My lord,
the assistant registrar, police, wrong. Was not submitted anyway. The case was fixed for, no, this is an application, so and so for you. The case was fixed for, the submission of, furnishing of at present health status report by the superintendent from the central jail, Guwahati. Yes, and as per order dated 2024, the registry was directed to issue reminder to jail authority to obtain medical report from Bibura Cancer Institute. The Bibura Cancer Institute, but from the report of the superintendent of jail, so and so, it seemed that till that this jail authority is not in a position to furnish the present health status report of the accused petitioner, though the correspondence were made by the jail authority. Mr. Biswas, the learned counsel for the petitioner, submitted in this regard that that the present accused petitioner is a blood cancer patient and suffering from leukemia, and though he is receiving the treatment from the jail authorities, not but though he is receiving treatment from the jail authority, and who was treated in Bibura Cancer Institute, but his health condition is still deteriorating, and when he got faint.
My lord, I have specifically stated, my lord, that the different he again admit 4/11/2024.
Health condition was deteriorated, and for which he had to be admitted immediately on 4/11/2024, where the blood was given to the present petitioner. Mr. Biswas further submitted that without going into the merit of the case, he filed the present petition for releasing the accused petitioner on bail exclusively on the medical ground, as there may be further deterioration if the accused petitioner does not receive any proper medical treatment inside the jail authority. In this context, he also relied on the decision of Honorable Delhi High Court, reported in 2023 SCC Online, Delhi 3270. And the order of the coordinate bench of this court passed in bill application number 1019/2023, wherein also the petitioner was granted bail only considering the health condition. Anything to submit?
Recently, Supreme Court says that if the bail is granted on medical ground, then medical board is to be constituted. Because lordship, here the petitioner was suffering from leukemia before his arrest, lordship.
Yes.
This is my submission. Recently, Supreme Court said last week, Lord, I place that judgment. If court thinks that he should be granted bail on medical ground, then opinion of the medical board should be taken.
Actually, what had happened, the opinion of the medical board was in fact called for the status report also.
6 months.
But the jail authority is not in a position to file because they sought for some more time. Then in that case, what do you want to say?
That documents provided by the petitioner that he is getting treatment in the jail, in the hospital also. And there is another judgment last week, also Supreme Court says that because here he was arrested in case of a narcotic.
Yes, yes, obviously.
And final complaint is already been filed. He has been made accused. There are sufficient material against him. Our apprehension is that he will misuse the liberty granted to him. Because there are many cases where bail has been granted, people are.
Yes, yes,
not-
I have also come across this
Yes.
kind. You won't be able to procure the attendance of the accused. Once he grant bail, he will
My lord,
flag.
I have a small submission here, my lord. I have a small submission here because these are unfounded, my lord. I'll say. There was a time, my lord, where the moment the court sees commercial quantity, bail rejected. Never ever went into the merit of the case. Therefore, my lord, 1 or 2% when they get bail, they know that courts are not going to, if they get interim bail, they come under the apprehension that courts are not going to grant bail. So that was an apprehension. Now, my lord, when my lord, random bail application are being allowed, I am personally conducting so many trials, nobody is defaulting. That was an era when commercial quantity bail is like, my lord, something fallen from heaven. So that era is gone. Now, my lord, so many people every day, even your lordship has granted bail this month on 3rd of April. Whoever is getting bail, everyone is participating in the trial. That era is gone, my lord. That era was only because bail in commercial quantity was never heard of. Even we as a council, when we are engaged, we know at the heart of our heart that it will be not there. We also don't. But slowly, my lord, when because of the delay in the trial and because of health issue, when bail was granted, everybody started participating. Everyone is, now your lordship will not find any complaint from the Kamrup Metro. Now everybody is participating. That was that era.
In as many as 3 cases, we are going to file lordship cancellation of bail on the ground that they have jumped the bail.
Out of 100, my lord, 3, it will not be even 3%.
It is not correct that in every case bail is right. Many cases bail is rejected.
Well, obviously, there are.
But in my lord, suppose my lord in 2024, suppose in 100 cases bail has been granted. Example, in 3 they will be filing, and I can show from record, my lord, in all those cases, in some of them, my lord, they have approached to the Supreme Court without issuing notice. Supreme Court dismissed their case. I can show all those judgments. But I'm not going into here. Here is a case of complete compassion. Complete compassion, because, my lord, if he dies, everything, all this argument, everything, we might also repent, my lord, that at least I appeared for a alive man and now I am to appear for a dead man.
Lordship,
Only on
interestingly, in
compassion,
this case, he was suffering from this ailment since he was arrested. If he knows that he is suffering from, then why is indulged in this type of offense?
Now, my lord, this is still at the realm of allegation, my lord, because nothing was recovered from his possession. Now, whether in a courier service, whether he has come to receive X courier, Y courier, Z courier, these are tribal issues, my lord. It is not a case where something was caught from his own possession. I am even a 3-month, my lord.
This is the judgment was bail was granted by Chhattisgarh High Court. Then Chhattisgarh approached the Honorable Supreme Court. Supreme Court, he was granted bail on medical ground. Offense was something and not NDPS, another something. But I marked the paragraphs that may be taken into consideration.
My lord, it will copy us in it. That's the issue. My lord, I am sure that is on a different context, my lord.
He was granted bail on medical ground only.
You want to see this one?
Yes, my lord, of course, my lord. I don't.
This is another judgment passed by the Honorable Supreme Court, where the bail was granted by Rajasthan High Court. The offense was from not NDPS, where also in case of heinous crime, paragraph 14, 15, and 16 the crime level set.
My lord, their own department, that is the NCB, my lord, when Shah Rukh Khan's son was granted bail on 26 days, they did not file before the Supreme Court for cancellation of bail. And there was allegation against their superior officers, my lord, of illegal gratification. Nobody is above suspicion, my lord. In Riya Chakraborty's case, my lord, those are all commercial quantity cases.
board examined for accidental to please the medical board examined on medical grounds respondent submit the medical board. That is why
But here if you see.
Yes.
The last,
I know. Yeah, you do.
that he was further direction was there that we grant liberty to the respondent to apply for interim bail again before the High Court.
Yes. That is why, my lord, I read their judgment. Now, again, your lordship will see para number 3 of this judgment. Yes, my lord, para 3 of that judgment.
Granting bail on medical ground, Supreme Court says that medical opinion of the medical board should be taken. Here in this case, you are suffering from this ailment since and for last more than 2 or 3 years.
Obviously.
And thereafter he was arrested in case of NDPS.
Now, my lord, this
Whether
submit.
he will be acquitted or not, that is question of trial.
My lord, that is precisely what I am saying. That whether he'll be acquitted or not, whether he'll be convicted or not, is a matter of trial, my lord. What I am saying is there, my lord. Here also, my lord, that is why, my lord, I want to read the judgments placed by NCB because it is very, my lord will see. Now, one of my friend has just now passed on their judgment at page number, at para 3, because the doctor's report was not consulted. What is the fact of this present case? Initially, when this matter was placed before this court, my lord, a report was called from the jail. Jail authority confirmed that yes, he is suffering from this. Then there were some other some other medical documents were also placed before the court. Then the court was of the opinion that we'll take a directed to for constitution of a medical court. Now, my lord, take an example, my lord. It is not a case where the petitioner on the motion date is coming and arguing that without any report, without any that I need bail. It is not a case of that sort. When the motion that this bail application was moved on. Very good. My lord will see. When was this moved? I'm sure it is at least 3-4 months, my lord. This bail application is, my lord, it has been filed before the court, my lord. Now, my lord, is it the fault of this under trial, my lord? What is the fault of the cancer patient? Somebody is the, my lord, tomorrow he dies, my lord, because I have shown, my lord, on 4th, my lord, because they will not bring all this on record. I have shown on 4th his situation, my lord. Your lordship has seen, even I asked my client that get a photograph because sometimes the documents are also not being believed. They got me photographs from the jail. These are the photographs of the jail. He's taking blood. Now, I am saying that 3 months, within 3 months, let them constitute a medical board. Let there be an interim bail for 3 months. Within these 3 months, let there be a medical board. Your lordship will review the will review the order maybe after 3 months, so that at least, my lord, both sides are balanced. If he gets treatment, if he can survive, it will help the prosecution also. For successful prosecution of the person from whose possession this contraband were recovered, if at all their allegation has any merit, then my client is one of the prime, my lord, witness or evidence. He is one of the prime evidence. Because according to them, if they are saying that I have gone to receive the contraband, then I know who have sent it. So if I go, there are 2 types of discharge, my lord. One is horizontal discharge and other is vertical discharge. So if I am vertically discharged, then, my lord, their case will also fall. Because it is not caught from anybody's personal possession. It is
What
in
do you say
transit.
if he is vertically discharged? If there is any vertical discharge.
Discharge are, and my lord, we all are member of this, my lord. We are a part of this society. At least little compassion will not, my lord, because there are n number of judgments where on medical grounds bail were given. It is not alien to the Indian law that on medical grounds bail were not given. Even there is a caveat in the CRPC that even a magistrate can grant a bail in case of life imprisonment on health issues.
Your Supreme Court order is slightly a bit different because their medical superintendent, there was no report, I think, from, yes. So that's why without any consulting any medical documents
Yes.
or any,
Yes.
that was granted. Only
Yes,
mere
that para
submission.
3 says that.
Only from the submission made by the student. So that is there. But here, otherwise, I don't know, go by the other case. But if you go by the case that obviously he is a cancer patient. That is
admitted. We are
accepted.
not denying. But Lordship, my contention is that he was suffering from this element since
Yes,
long
before his arrest. Before his
Lordship,
arrest.
it is not in the case of the petitioner, he is not getting treatment. He's getting treatment in hospital, Lordship. Lordship,
My lord, it is very difficult to
He's a-
save a man.
he is a resident of Tripura, Lord.
Tripura.
Yes.
Tripura, my lord, Tripura is nearby. People from Bihar, UP, all are arrested, all are granted bail. Tripura to nearby.
That is the difficulty, Lordship.
Tripura is, if required, my lord, they will give surety of local surety, they will give. Maybe one of them may government servant.
Here in Kamrup Metro, we know there are 3 government servants. One from Water Inland Transport Department, another is from a railway department, and one is from somewhere. They are the government security. They stood everywhere in government security. Security, that is the problem.
Lordship in lower court, the bailers are available. Like,
Available,
it will be
even the
purchased.
government security are available.
That is available.
Now, my lord,
This is the difficulty.
my lord,
No, just I'm saying that is the practical position.
My lord-
So they can arrange anyway.
my lord,
If your lordship to
my lord. In 1973, there is a judgment, my lord, in one of the cases I have read, my lord, where rendered by Justice Krishna Iyer. He said that geographical allergy at the judicial level is against the rule of law. If somebody
We
is
can
from
understand,
Tripura and
but the practically is different, situation is different. We can understand geographical, that is true. Security can be maybe local means entered from the India also.
And-
In some of the judgments are also there. It's not that it should be from Assam or it should be Guwahati or Kamrup district only.
Madam.
Local can be from anywhere. But practically there is a problem. That is it. That
Madam,
is the
that is
question.
what, madam-
Otherwise, I am not on that.
my lord, that is what I have submitted, my lord. That was that was a time in Kamrup, my lord, because my lord, we have also seen for 18 years, my lord, I am also there in this profession, my lord. We have seen, my lord, during those time when bail was rare of the rarest. My lord, nowadays, bails are granted after 2 years or 2.5 years. Nowadays, my lord, that situation has, my lord, come down drastically, my lord. Now nobody is jumping the bail. Everybody is participating in the trial, my lord.
lordship, just for reference, in one case, the accused was convicted. He was granted bail that his father was expired. Therefore, he jumped the bail. We didn't report to the, now CBI.
I was there. I was
This
there.
honorable court,
As a session judge, I was
yes,
there.
lordship, this honorable court has instituted CBI inquiry in that case.
Yes, yes.
And the
Inquiry was there now.
the court.
Now whether the bailer was genuine or
Yes.
not, these sort of questions have
Yes,
come.
lordship,
I know. I was there.
there are many instances are there.
So and so, দিছে না? Mr. So and so দিছে। বাকি তেওঁৰ submission হৈ গ'ল। Mr. Kyle Learned Standing Counsel and CB further submitted in this regard that the present accused petitioner is reported to be a cancer patient before his arrest. But even knowing that his medical condition, he was indulged with such kind of offenses, and he is the accused who was to receive the parcel of the contraband. This is a case of commercial quantity, and sufficient materials are also against the present petitioner. Mr. Kyle further submitted that the case has already been charged sheeted on 4/12/2023-24, finding sufficient incriminating materials against the present petitioner. Mr. Kyle further submitted that in the jail authority also the present accused petitioner is receiving proper medical treatment, though the present health status report is not available before the court. In this context, he further submitted that only considering the health ground, the person alleged to have been committed such heinous crime should not be considered only on the medical ground. In that context, Mr. Kyle also cited a decision of the Honorable Apex Court passed in criminal special petition, criminal number 39395 of 2020, wherein it is observed by the Honorable Apex Court that before considering the case for grant of bail on medical ground, the court should get a opinion from the medical board or from any public hospital. Accordingly, he submitted that the prayer for accused petitioner may not be, she may not be enhanced on bail. However, direction may be given to the jail authority to provide proper medical treatment to the present accused petitioner. Mr. Biswas submitted in this regard that the citation which is relied by the learned Standing Counsel NCB is of past year of this different context, wherein there was no medical documents consulted by the High Court while by the Honorable High Court while passing the order on bail on medical ground. Full stop. But here in the instant case, it is the admitted position that the accused is suffering from blood cancer, and his health condition is also deteriorated day by day due to non-receipt of proper medical treatment inside the jail premises. Mr. Biswas further submitted that he may be any strict condition may be the bail may be granted by in by presuming any strict condition, and he is ready to abide by all conditions and is ready to provide the genuine bailer if he is granted with bail. Next paragraph, considering the entire submission made by London Council for both sides, and also considering the reports earlier submitted by the jail authority and the petitioner side, it is seen that the patient is suffering from the leukemia, and presently he is getting treatment from Vibhura Cancer Institute. But at the same time, it also cannot be denied that he was also urgently had to be admitted in the hospital and wherein the blood has to be given to the present petitioner, considering his status. But in the same time, it also cannot be denied that the present petitioner is an accused of a heinous crime wherein the commercial quantity of contraband is involved, and from the matrix and from submission made by the learned submission made by Mr. Kyle, it is also seen that he is one of the main culprit in the alleged offense, and charge sheet has already filed against the present petition. However, without going into the merit of the case and other aspects of the case, only considering the medical ground or the health ground of the accused petitioner, this court is of opinion that interim bail can be granted to the present petitioner for 3 months. We are granting him 3 months bail. We'll see to it, and in the meantime, because in absence of the accused petitioner, there may not be possible to get a health status report. Let him surrender before we'll fix a date.
We provide that trial will not be affected if he remains absent.
Trial.
We'll file an application for dispense in case.
Trial may not be affected, only for the absence of the accused petition. It will be.
Season condition may be.
Yes, we'll provide. We'll ask to provide, furnish the PAN card, Aadhaar card, etc. Also, one government security will be there. 3 months will be there only. Only exclusively on the medical ground, no other issues.
Earlier he took treatment in Tata Memorial also.
Yes.
That is also recorded by this honorable.
Yes.
But my lord will just not give one condition, because that might again make me come for an IO, that he will not leave the jurisdiction of the Kamrup Metro, because if he has to go to Tata Memorial, then he'll have to give to Bombay. Only that condition will not.
File application before the trial court can take permission from the trial court.
But my lord, these things are easier said, my lord.
In the video, that I not mentioned so and so, but however, if he has to visit any hospital beyond the jurisdiction of the so and so, he may seek proper leave from the Rani Special Justice. Okay. This was.
So this is 438 application lordship, and earlier interim was granted lordship, and he already cooperated with the investigating agency lordship. And lordship, so far FIR is concerned, lordship, the petitioner name is not in the FIR lordship, and at earlier occasion lordship, and it is come to learn from the CD, and one Sanidul Islam lordship, and that is another Sanidul Islam, but I am from Goalpara, and another Sanidul Islam is belong from Sargav, under Sargav PS Lordship in Kamrun district Lordship. So there is the discrepancies and who is the involved in this case Lordship. But the present petitioner is a driver of a vehicle Lordship, and he operating the vehicle and his car is used by on rent by different person Lordship. So then it will.
No, we have received the case diary, my lord. I require some time to go to the case diary, my lord. Because there is a two Sanidul, my lord. That's what my learned friend committed, my lord. Just have to verify, my lord. Actually, one person, my lord, he received the stolen property, my lord. In connivance with the my lord main accused person. 250 bags of my lord, Erekanat, my lord, it was Dokaiti committed, my lord. And they, my lord, they sold out all the 250 bags of Erekanat, my lord. Now, my lord, only my few bags are yet to be recovered, my lord. Others are not yet recovered.
Only how many recovered? 250.
No, out of 250, my lord, only few bags are recovered. My lord.
Okay.
And it was some time, my lord, he's on interim, my lord.
This is again from Dharamtul.
That is a very old case, Lordship. In the month of Lordship, and I grant interim in the month of April, Lordship.
No, there are same similar nature of case from Dharamtul earlier also regarding this Erekanats. The theft of or ducati of Erekanats.
Yes, sir.
He's seeking for some time only.
Lordship.
Pardon?
Any date, my lord?
Oh, you want a date?
No, my lord.
Oh, I thought this at 2.
Date was sometime,
Oh,
not today, my lord.
Forget to CDI হিসেবে কি করব আর 16 17 18 দুই করে করো আর 17 we listing it on 17 list on 17 CDB written okay you're seeking time CDB written কই টাকা list on
Ablash Lordship.
53.
This time.
My lord, OPC also arranging up to the same case, police case, my lord. For interim authority.
Yes, Lordship, there is an.
you are also in injury
Interim,
My
so
lord, in
same
this
day
case,
on
my lord,
17 12
he has not appeared before the my lord investigating officer, my lord.
He has appeared, Lordship.
But my lord, in the note of the investigating officer, my lord, it stated that he has not appeared, my lord.
But the petition has appeared, Your Lordship.
no but we don't have any record that you have appeared that is not there in the CD.
But that is the version of the petitioner informed to us.
Want to dispose
Yeah,
it
my lord.
today or on 17th?
No, my lord, 17.
On 17th. Take instructions from your client
Right.
when he appeared, because as per Mr. Burwa, there is no such, there is note, in fact, from the IO that he has not appeared even after obtaining the interim, in fact. We are fixating on 17/12. Take instruction.
Interim shall be continued, Lordship.
Pardon?
Interim shall be continued.
Maybe
Yes, in both the matters, interim shall be continued. Yes,
Oblige, Lordship.
one matter only. But it is an admission matter.
Yes.
Oh, it will take time. Half full to do, no, half down to do.
For admission, item 13.
Well, in this case, I have prayed for transfer of one complaint case pending in the court of Galpara in Nagaon, my lord. Then, my lord, the petitioner is the wife and the respondent is the husband. And they are living.
In this case, Mr. Das, where there, you have not taken any steps to the respondent side, for the respondent side? It is a transfer of what case, what nature of case?
He case transfer. Matrimonial divorce.
Yes,
Matrimonial matter.
no, the case I want to transfer is a complaint criminal case, my lord. And one matrimonial case is pending at Nagaon. The wife has filed a divorce case at Nagaon. And after receiving notice of that case, my lord, the husband has filed a complaint case at Goalpara against the wife. So I want that case from Goalpara to be transferred to Nagaon, my lord. No, husband has alleged that his wife came to his house at Lakshmipur in his absence and broke the door and also the almirah and took 50,000 rupees. So this is the false allegation against his wife, my lord. That is the complaint. And he's not taking any step, my lord.
Just a bit problem is that it is a matrimonial matters and complaint is there. So you're seeking transfer, but the notice is not yet served on the sole respondent.
Notice is really served.
Served?
Yes, ma'am.
No, but report says it's not yet served. I mean, from the report of the office report.
Notice several times, notice has been served during last 3
No,
years.
notice was issued undoubtedly, but it is not served. Service did not be received back. So do you want it to be awaited because it is a case of a complaint on the complaint case, so the respondent is the necessary party. Your petitioner may be genuine, there may be a transfer also, but the question is unless and until we hear this one, because report is yet to be received. It is not yet returned back, in fact.
Accepted, ma'am.
Pardon?
Service of notice has been already accepted, ma'am.
Accepted. What was it?
Order দিতে তো কি ম্যাম
Hmm?
accept order
Say name.
accept order
What is it?
this issued
Mhm.
It will last.
accepted order
Ask it.
Issuance.
Last order,
Notices here.
last 2 orders.
Check consignment report is also there.
No, এটা order আছে, track consignment report to আসলে, but service to tar logot নাই. Here it is there. Basis of postal provided by the dispatch section, track consignment report is not found out of the Indian postal. Track consignment is also problem A2 particular of 9. We did registry also tried to get a consignment, track consignment report. There also, this number is not there in the track consignment report. That is still missing, in fact. So now, what to do? Otherwise, the criminal transfer, no? To Dusty Covid in the otherwise to Dusty is not
That receipt is already in record, ma'am.
because we have this one, these things are also with us. If you want to parallel, we can show you. But no report is not there. From where you are saying the service is already completed?
Not that may be given, my lord, I'll examine the record.
Examine the record.
No, I have already given a check record I had submitted.
That's what here it
Yes,
is.
sir.
On the basis of the postal
And in Loajima
found provided by the dispatch section, track consignment report is not found out of from the Indian postal website.
the Loajima report.
Lojima portal ke pathai diyo niki na.
They can be done for a report.
Then we will send it to Lojima code then.
Lojima.
Lojima code, we can send it. They will provide us they will furnish the report in regards to service.
Yes.
এইবিলাক আর আছে নেকি ৰ'ব ৰ'ব। এইবিলাক কি আছে? Issue reminder.
Loajima code has accepted, ma'am.
The reminder has gone.
Who will see them?
This one. Lojima ta গৈছে এইটো এইটো।
Today was the pitch for record of the lower court matter after accepting service of notice.
আছে নেকি? এইটো আছে নেকি? Very short list. Lojima report or report to go. এইটো নেকি? As per.
My lord, the last 2 orders may be serviced.
And because our unsubmitted has been received. Copy of the postal dispatch section track concern report has been traced out from the Indian postal. The report reflects that the item is delivered to the addressee on demand. Both the postal and track concern report are placed. It will report pieces of the order within the court order is the No, this is the Lojima court order. Aru ব্যক্তি court order হৈছে নেকি? তাৰপিছত subsequently after furnishing of the report by the Lojima আমাৰ এটা order হোৱা নাই নেকি? We have received issue reminder. Since the one has been finalized, the petition is disposed on merit. This one is not present today. জমা কোর্টের উপর রিপোর্ট কোনো আনে না, অর্ডারে কোনো আনে। report আহিছে নেকি তলৰ পৰা? Record আহিছে নেকি? কি কৈছে বা একো গম নাপায়, অৰ্ডাৰ বিলাক একদম নিয়া না। Services complete. আচ্ছা এইটো লেখাইছে অফিস নোট 21(3) admission column. Interim order continue. Filling this petition, filling this proposal, and edits. Record call for police. Not received. Received. Type of record is received. Okay, there is one order of Lordship Court we have seen now. Wherein it is stated that the service was there through, registered AD.
Yeah.
That is report is of 4/1/24 and on the basis of which one order is there, 21/3/2024. 21/3/2024. Yes, okay, what is the case?
Case to copy.
Oh,
What is the case?
Hmm?
That's not what's the code, case to code.
Wait. We'll hear to it at 2. Because we have a meeting, in fact, full court meeting. So we'll hear it at 2. We have received the record also. We hear at 2. We hear.
Yes.
Yes. What is the ground you're seeking transfer?
The petitioner is the wife and the respondent is the husband. They belong to the tribal community and they belong to very poor family. The respondent is a daily wage earner. He lives at Lakhimpur in Gwalpara district. And the petitioner now lives in her father's house at Kotiatuli in Nagaon district. The petitioner and her minor daughter was tortured by the respondent, and for that reason she could not stay with them, fearing their life, that there will be fear of life of her, the daughter and herself. So she was staying at the father's house. The father is also a very poor person. So the respondent was not paying any maintenance while she was staying in her father's house. Therefore, she filed a divorce case at Nagaon. That one is divorce case number 127 of 21. After receiving notice of this case, my lord, the husband filed a criminal case under section 448 CHT at the Gwalpara court, complaint case, my lord, alleging that she had gone to Gwalpara with one of her relatives and had broken the door of his house and also the door of the Albera and took a 50,000 rupees from his house. That is the criminal case pending at Gwalpara, my lord. So she has received notice at her father's house. Now, if she goes from Kotiatuli of Nagaon district to Gwalpara, my lord, she cannot come back on the same day. She has to stay at Gwalpara, and she has got a minor daughter. She cannot go. But she filed a divorce case at Nagaon. Husband has to go there, my lord. So he will appear there for that reason, my lord. As I am unable to go to Gwalpara on every date, I want the transfer of the case from Gwalpara to Nagaon. That is my testimony.
So who is petitioner number 2?
Yes, municipal number 2, Gwalpara, municipal number 2.
No. Who is the petitioner number 2? Putul Rabha?
There is paternal uncle, madam.
Why he is petitioner here?
His respondent's allegation is that with Putul Rabha, she had gone to his house at Lakhimpur and had broken the door and had taken away the money. He has also been made an accused in that case, madam. So we have made him also a petitioner.
আহিছে নেকি এইটো? So presently the case is pending before Munship number 2.
Yes,
Come
Munship
judicial
Magistrate
magistrate.
number 2 at Gwalpara. It is pending there. Now the record has been called for, my lord, and it is approved here.
But Mr. B.C. Das, the learned counsel for the petition. From the office note, as well as from the report of the Laws in Court, it is seen that the notice is duly served on the respondent number, sole respondent, but he remained absent and no one has represented the respondent number 2. Next para. This is a petition under section 407, bracket of 1, or bracket of small Roman 1 of the CRPC for transfer of the case number CR 21 of 2022, pending before the Court of Munchief Magistrate number 2, Goalpara, to a similar competent criminal court at Nagaon. It is submitted by Mr. Das, the learned counsel for the petitioner, that due to the physical and mental torture on the petitioner number 1, she had to institute a divorce suit, she had to institute a matrimonial suit, bracket of divorce, in the court of District Judge Nagaon for dissolution of her marriage, with the respondent by decree of divorce, which is numbered as matrimonial suit, bracket of D, number 127 of 2021. After getting the notice in the said divorce suit, the complaint has been lodged by the respondent number 2 against the petitioner number 1 and the respondent number and petitioner number 2 with some false and concocted allegation, which has been registered as CR case number so and so before the court of CGM Goalpara, and which has been transferred and now presently pending before the court of Munchief number 2 cum Judicial Magistrate First Class Goalpara, being numbered as CR number 21 of 2022. It is submitted by the learned counsel for the petitioner that petitioner number 1 is a very poor woman and she has a minor daughter, and hence she is not in a position to attend the court attend the court of Munchief number 1 Munchief number 2 at Goalpara on each and every date, leaving her minor daughter. The distance from Nagaon to Goalpara is also sorry, there is in it to further he submitted that from Nagaon to Goalpara is quite a long distance, and hence she cannot return back to her place after attending in the port of Goalpara. She has no one to look after her minor child, and leaving her minor child, and also she is not in a position to incur the expenses for attending the court at Goalpara. More so, as the divorce suit is already pending before the court of Nagaon, the respondent is facing trial before the court of Nagaon, District Judge Nagaon, and hence it will be convenient for both the parties to attend the court at Nagaon instead of at Goalpara, and accordingly the present petition has been filed for transfer of the case number CR 21 of 2022, pending before the court of Munchief number 2 to Munchief number 2 Goalpara, Munchief cum Magistrate number Munchief 2 cum Magistrate GMFC number GMFC Goalpara, to any other competent criminal court at Nagaon. Next para, hearing the submission made by the learned counsel for both sides, it is seen that a complaint case is lodged against the present petitioners before the court of CGM Palpada, and which is pending for appearance in the court of Judicial Magistrate First Class, cum Munsif number 2 at Palpada. And cognizance has already been taken against the present two petitioners by order dated 29/05/2022. Considering the submission made by the learned counsel for the petitioner and other materials available in the case record, it is seen that the one case is already pending before the court of district on Learned District and Session District Judge Nagaon. Already pending. Divorce suit is already pending between the parties in the court of Learned District Judge Nagaon, and hence for Nagaon, and considering the grounds mentioned in the present petition for transfer, I find that this court is of opinion that it is a fit case wherein the case number, CR case number 21 of 2022, pending before the Learned JMFC from Munsif number 2, Gwalpara, may be transferred to any criminal court with competent jurisdiction. With the above observation, the present petition is allowed. Accordingly, and the CR case number 21 of 2022, pending before the court of Learned JMFC Munsif number 2, be transferred to the court of CGM Nagaon for onward transmission to any other competent court with any other competent court with in any other competent court to having jurisdiction to try the same. Registry will record. This one is the scan copy. The Learned CGM Gwalpara will accordingly take necessary steps in transmitting the case record to the court of CGM Nagaon. A copy of order be accordingly furnished to the court of to the court of Learned CGM as well as the concerned court for necessary order. Both the parties are also directed to appear before the court of will appear accordingly with the above observation. The present transfer petition is disposed of. Okay, your petition is allowed.
Thank you. 50.
Yes, এটা কেস আছিল কিন্তু কিবা যে হৈ গৈছিলে এটা হৈ গ'ল এইটো কি আছিল NMB চৌধুৰীটো another date or at 2
It's fixed on 16.
16 to
16. Conjunction.
okay. It was from NCB.
Yes.
May please, your
Yes.
lordship. My lord, office note dated 17/2/24, lordship. Lordship's learned counsel for sole respondent entered appearance. My learned friend has appeared. Scanned copy of LCR is received. Lordship, this item is ready for admission hearing. Lordship, another case is pending, lordship. Criminal petition number 727/2023.
Criminal
Between the-
petition number
727/23
727.
lordships. Between the same parties lordships. Lordships, my humble prayer, both the matter may please be take together and after vacation lordships may be listed for admission hearing lordships.
Case is
My-
already long pending, my lord. It's a case against my lord, check bounce, my lord. Even if case is, my lord, transferred, my lord, they are spread for, I have no objection because it is seeking transfer from Dorang to Kamrup, my lord. The case is pending, my lord, since last 2 years, my lord. But that while origin a transfer petition was filed, my lord, that there was no stay, my lord, as such that lower court proceeding was continued, warrant was issued. That warrant was challenged before this court by the another petition, and that was further proceeding stayed. Ultimately, my lord, that check bounce cases, my lord, he got relief, my lord. That's why, my lord, it's a very urgent. So even if transferred, I have no objection. Your lordship may pass appropriate order.
So what is your, what did criminal petition, other criminal, this is also transfer petition or
Not, my
stay
lord,
of MBW
my lord, only warrant of arrest of
was state?
warrant, my lord, that was stayed, my lord, and further proceeding was said that. It is
Why it is pending for?
not that any sort
If warrant is already stayed, suppose, why it is
warrant
pending
is
for
stayed, my
again
lord, and
pending?
further proceeding also stayed, madam, in this
Yes,
complaint
understood,
case.
understood. Then why it is pending for disposal, criminal petition 727? For what reason?
Pending,
He could have, no, no,
He was pending.
I mean,
Lordship-
why? it is-
Lordship, this
Because
matter,
notice was issued and earlier proceeding was said, and notice was issued to the sole respondents. Because it was expert initial at the motion stage, my lord.
21/7/23 lordships, that 727, it was listed for motion hearing. On that day, it was stayed lordships. Thereafter lordships, the matter is not listed. My learned friend, he has also entered appearance in 727 lordships.
No,
Now-
no, I'm not.
On and lordships, as in both the matters between the same parties.
Early date may fix, my lord. Here today or early date may fix.
Early date we don't have.
After vacation.
Short date we don't have. Short date in a sense, prior vacation, we don't have any date. It will be obviously after vacation. So we'll pass the order immediately after vacation,
Immediately after the
then it may come.
Lordships, both the cases together.
criminal petition 727.
At a request made by the Learned Counsel for both sides, list the matter according with criminal petition number 727/2023. After vacation. Immediately after vacation, immediately after. vacation. Oh,
Lordships.
See,
For the respondent,
Oh,
there is a stay operating on the 125 proceeding maintenance. Will not appear to us.
this was, I have seen in the morning hours, most probably, oh, she is there.
May I please the lordship? Lordship, I am appearing for the petitioner.
Yes.
The petitioner, the respondent has filed their written objection.
Mm.
Where they have stated the allegations made against her are all false and fabricated one.
Oh, we are not on that. I mean, this is only the transfer. What is
Transfer of the petition.
your problem and why it should not be transferred, that much only. We are not going to the merit of the case
Okay.
otherwise. So why you need the transfer?
Lordship, he's an employee of the Guwahati station, and it is difficult for him for going every day to the Bongaigaon for appearing in his case. And also he has got life threat because the wife has some extramarital affairs, to which he has lodged an FIR in Bongaigaon in the year 2019. That we have stated in our petition in para number 7.
So basically you are the employee of Railway Bongaigaon. Sorry, Maligaon. And the case is instituted where?
In Bongaigaon.
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 So it
And
is
he has
difficult
also
for
got
you.
a life threat.
Life threat. Okay. Yes, what is your suggestion?
There was a divorce petition filed by the husband. Initially, in the year 2000, initially there was a divorce proceeding, Your Lordship, that was withdrawn, and then both the parties started to live together again. Subsequently, again she was driven out of the house, and another divorce proceeding is filed. That
By the husband?
by the husband at Family Court, Kamrun. Against that, we have preferred a transfer petition civil for transferring the case to Bongaigaon at the place where the wife resides.
That transfer petition is already allowed.
Not notice has been issued, proceeding of the case is stayed, and they have entered appearance in the transfer petition civil for the divorce case. And side by side, we have filed this maintenance case, saying that since he is asking for divorce and he is not paying a single penny to the wife, there are medical conditions. We have annexed documents. The wife is suffering from tuberculosis, TB. He is not paying a single penny. So we have prayed for maintenance and filed it in the place where the wife is residing in Bongaigaon. And they have come praying for transfer of the maintenance case from Bongaigaon to Guwahati without paying any penny, and they are asking for divorce as well. This is the situation, and that this case is also stayed because of the pendency of this transfer criminal, the maintenance case. And another ground that was stated by them in their transfer petition was that he had suffered a fracture of his leg, and as such he cannot go to Bongaigaon for attending the case from day to day. But that order, that was also 7-8 months back, Your Lordship, when the case was filed, and the maintenance case is still pending, Your Lordship. There is a stay. So fracture in all circumstances would not last for that long. Now he is fit and he can attend at least the maintenance case.
This is transfer for the maintenance only.
Maintenance. Filed by the husband. The husband is paying for transfer. And on the other hand, the husband has already filed a divorce petition. Is the conduct, Your Worship.
Divorce petition in Kamrup Metro.
Family court.
So you are seeking transfer to Bongaigaon.
The medical grounds, medical documents we have annexed with our affidavit in this case as well. The last page, Your Worship will see, there's a final diagnosis that the wife is suffering from TB as well. At page 53 of my affidavit, Your Worship. And he is not paying anything, any maintenance. The wife has medical conditions as well.
Over.
May I please, Your Lordship?
And your transfer petition is also pending. Yes.
Well,
What my learned friend has said, partially true.
fully. It is fact that the day she filed the maintenance case, asking me I am going for the maintenance, same day I have filed divorce suit at Guwahati. Earlier also several times suits were filed divorce because she came back, she said that I will never do. I will live with you. Then I have withdrawn the cases. Now, in this case, she is suffering from tuberculosis, is an admitted fact. And when she's getting the treatment on my behalf, because she's my wife. She's regularly coming to the Maligaon Railway Hospital and the TB center, Maligaon at Pandu, for regular medicine and checkup. As my wife, not as a stranger. Now, 125 case, I have paid last occasion, I have money. Now also I have paid, need to pay. She must do something better, either to stay with me or to separate for him. But I will leave on hanging, my lord. She will not come. She will come. Several times there was a compromise. My lord, in Bongaigaon I could not go. There was a threatening of my life. I filed a criminal case. That the day I have prayed for a stay of the proceeding, it came before your lordship. And I have shown your lordship the criminal case registered against them. Later,
it was compromised by the OC. They don't do a give because she has an extramarital. I should not say she's my sister. Should not say extramarital relation with other classmate. And after marriage was given against her wish by her father. That's why that is. Though I am a small person, my lord, I'm working as a mechanic in the railway department, but I have kept her very happily. I get a lump sum salary is around about 60,000. So I for her wish, I have given her everything. Even she wanted to leave separately from my mother, that also I have allowed. But she'll come, she'll stay for some days, she'll again go away. I have to go pursue her. Her parents give me, come back. That is the reason. Yes, my lord. What I pray, my lord. Unfortunately, I tried to bring my client, my lord, to go and bring her again, negotiate the matter. That's why we did not file the reply of their affidavit. Otherwise, we may be given a week's time to file affidavit of reply of. Otherwise, my lord, both the cases may be taken together. Divorce matter and this case for transfer, vice versa. Not if I am asked to go there, I have to go there because I want settlement, final settlement. I am hardly about 34 years age. If this way drag another 10 years, my life will be spoiled. This is the practical solution I want, which I hope my learned friend will cooperate with me. And I request my friend to help us to overcome this problem.
So if you want to help your wife, if you want to give her maintenance, then why stay was prayed for? The stay is there. That is stay is operating. In fact, he is saying that. So for the stay, most probably she is not getting any.
Before my authority to deduct my salary from my salary. That also under consideration. And I have personally authority asked me if there is such prayer, you deduct salary, from my salary.
But it will not deduct it because it is operating now.
Proceeding is state, that's why, my lord. Proceeding is state. My lord, without proceeding also, my lord, no question of ignoring her. My lord, that I have already submitted very outside that she is getting treatment regularly for her tuberculosis treatment. It is because she is my wife. I have recorded her as well, and she is regularly visiting the Guwahati. Then what is the wrong, my lord, to attend this 125 may be also settled here, and for family court is also there. Family court, she has to appear personally. You know, there is a provision of family court. Both the person have to appear personally. And now I have to go to Bongaigaon. If required, I will pay her expenses from Bongaigaon. Though she has got a pass on my behalf, railway pass is there. All facilities even then. Her father, her parents are willing, pressurizing her. You go and stay with your husband.
Why don't you talk to your parents, client now?
There are chances, your lordship. There were negotiations as well. This is not the first divorce case, your lordship. Previously, there was another divorce case. After that, they started living together, your lordship.
That has been withdrawn.
Again, that was withdrawn, and after that, again, she was driven out of the house.
I never driven out. There is mediation.
Lordship, whatever.
Let them come here, sit together, let them try to solve it. But I don't want to break the family. Young couple, no children.
Allegations and counter allegations, your lordship, these things will be taken care of in the divorce proceeding. My humble submission is that if there are chances of mediating and reuniting them, I would be happy. And that will be taken care of in the divorce. But in this maintenance case, your lordship, the conduct, your lordship, in the divorce petition, I don't have any problem.
Their rights should be saved. Family relations should be saved.
Certain.
Young boys, they will have a divorce marriage. You know, there is a mark of spot in their life.
Certainly, your lordship.
She's divorcing.
But in this case, your lordship, 125, just to show the conduct, your lordship.
My conduct is not bad. My conduct is very
good. Had they
good.
been so humble and so generous, your lordship, they would have easily paid some amount to the wife, so she would not have filed this 125.
She is so rigid in her recourse act and nature, my lord. She will never approach me. She will never ask me to pay money.
You have account number. You send it directly to her.
Will she accept? I will pay. Tomorrow I will pay.
Directly to the account.
She may not accept it.
Account.
I will see you in the court. That is the problem. Ego.
Account transfer.
Yes, account
No
transfer.
question
She may not accept it. She will remit it again back to my account. So, my lord, give me 15 days time. and let there be, if possible, my lord, mediation.
Mediation is okay, your lordship. but
My,
the
my
stay-
friend, I request my friend to help me for 15 days for mediation.
The
If
stay-
it is failed, my lord, then it will take its own course. I have got no objection.
I have no objection to that, but the stay order may be vacated, your lordship.
Then I know.
At least
For the time, 15 days, may
Lordship
stay
will
order,
take under.
15 days stay order. 15 days stay order will not harm my learned friend.
I mean, my client.
And today I will talk to my client to send some remittance either through you or directly to her account. No, you are the local person of Bongaigaon, that's why.
Not to him. Send some money.
I'll send, I assure you also. Otherwise, I will withdraw from the case if he fail to listen to me. I tell him, but I have got also heart. The woman will be suffering like that, wife should not. There should be some reason, rigid reason.
Had Mr. S.C. Biswas, the legal counsel for the petition, and also have Mr. Vijay Mukherjee, the learned counsel for the respondent. The respondent has already filed a written objection. Accordingly, Mr. Biswas submitted them. He needs some more time to file their affidavit in reply. However, Mr. Biswas has submitted that he is trying his best for conciliation between the parties and prayed for sending in a matter before the mediation. Mr. Mukherjee submitted in this regard that as the matter has already been stayed, the respondent is facing trouble and trouble. However, considering the submission made by both the parties, let the matter be listed. Short date 15 days of it or to date 9, we don't have any date. After Bihu will be convenient or it will be not? It will be too long.
Too long. It will be 1 month. After reopening, before Bihu if possible, first week of January.
That is the question. We don't have any. Date to my lab. I don't know if your priority is South Nahara now. We don't have any dates, in fact. After Bihu or
Yes. There's some assurance that they will try to.
In the mediation also will be ordered. We'll try to bring both. Let there be union up to both the soul, my lord. I will try.
Thing is, she's suffering from second disease.
So what? Disease
coming
will
out-
go over when they will live together. You see.
Bihu they occupy to land. Immediately after bifurcation, that is on 22nd January. In the
Yes,
meantime,
ma'am, because
Mr.
I will be
Biswas,
out of, I will be
you
in
just
home, my lord. That's why
see-
let it be 22nd.
See if some. It
I
can be
assure you,
because
lord. I
stay order is
Yes, yes,
stay
yes.
is operating.
Sure,
That's
sure.
why he is
Sure, ma'am.
facing. They try to reunite the two souls, isn't it?
Sure.
He will try.
Yes.
As a council, you also try.
I'll
We also
try.
want
I'll
that
try
families
that
should not be
paperwork.
separated.
I'll
Yeah, this
definitely-
is also view is
Sure.
there. Try something if some solution is there.
Yes.
We otherwise we are fixing 22nd. 22nd of 2025 January.
17 to 22.
Ye bol. Oh my God. Huh? 17 to 22. All are here. 17 to 22. Yes.
Calamity be adjourned to their lordship and fixed on 16, your lordship. The engaged constable Jadalam, he was present in the first half, your lordship, but he has he's yet to go to Pokraja, your lordship, for some personal problem, your lordship.
These transfer petitions, some are filed by you and some are filed by other side.
No,
Or
my lord,
same.
all the filed by my lord,
All filed by you.
Yes, your lordship.
my lord, they are enjoying their stay, my lord, they 4, 5 times they took
Only on
time, my lord.
16.
Lordship will go to the orders, my lord.
16 not possible.
16, lordship. Sure.
16 we don't have any dates. Prior vacation we don't have any dates.
Then your lordship on the third, your lordship, since the opening of the vacation, your lordship, first day of the vacation.
But stay is there, na?
Yes, your lordship.
What nature of case all these cases are?
Your lordship.
All are NI.
NI, your lordship, from the transfer from.
You want to avoid only by getting the stay and this avoiding.
Your lordship, in the first half, he was present.
From where to where you want to get it
Uh,
transferred?
My lord, cases are filed in Odalguri.
Odalguri.
Now,
Odalguri to
my learned friends, clients belong to Mongoldoy.
Dalguri to Mongol, your lordship.
Odalguri only hardly, my lord,
He's having some
40,
threat, your
40,
lordship.
50, 40, I think 40, less than 40 kilometers in between.
Yes, yes.
Your lordship, you don't have.
Not so far. A person can attend from
My lord.
Mongoldoy to Udalguri
It
even,
is
and
last
from
6 months
Udalguri
they are
to
enjoying the
Mongoldoy
stay.
even.
That is where.
It's not a place that is too far from Mongoldoy to Udalguri or Udalguri to Mongoldoy, wherever. And if you don't have any objection, let the petition be transferred to so and so. If there is any, I won't say. You have objection.
Udalguri. There is no reason why it should be transferred, my lord. There should some genuine reason, my lord, to transfer.
Generally.
To interfere with the my lord. So there is
So
no
otherwise, all these are NIAC matters for transfer.
all. There is no ground.
Third corridor pipe. 3rd of January or can be, I think. 3rd of January.
3rd of January, maybe 7, my lord.
7.
The
I
first
don't
day
know.
of the opening day of the new year, my lord. May not be possible in staying in Guwahati, my lord.
Then too it will come after Bihu only. 7, because this week is full. In fact, from 3rd, only one day is opening, otherwise from 6 onwards. 6 to 10, full. We don't have any dates. That will be after Bihu only. 22nd, 21st, whatever you want.
21st, my lord, then.
21st?
My lord.
Okay, we are listing it on 21st.
My lord, in some cases, in my 2 cases, my lord, there is no stay, my lord.
Entry was
In fact.
continued, your lordship, in the last occasion, entry in all the cases were continued, your lordship. The last order. Your
19, 20, 21. You are applying for 19, 20, 21. In your cases, interim is continued.
The last order, your lordship.
Suppose 19, 20, 21 interim is continued.
17 and 22, my lord.
17 and 20, 17 and 22, 17 and 22 no interim. All bele bele ke maribo na.
Your lordship, last order, your lordship.
And 18 who is appearing? 18 is there any interim?
One appeared, your lordship.
No one appears. Is there any interim in 18?
Yes, your lordship. As per the
have
last
to
order, your
check.
lordship, interim in all the cases were continued, your lordship.
Hmm?
As per the last order, your lordship, interim.
Etu
in all-
beleg dekha. Etu beleg etu nahi. This is 17 or 18 একেলগে কৰিছে নেকি?
26 and item 18 or 17 or 22. 17 and 22.
17 and 22. That is your effective returnable date. আগতে দেখোন stay নাছিল। Continue till then. So what did it was? It will be now. All cases is operating. In fact, there was no. From this table. কোনে কৈছে এইটো অৰ্ডাৰে নহয় মিষ্টেক ইমান আছে সেইটো কন্টিনিউলি ইন্টাৰিমৰ কুৱেশ্যনে আছে বাট এট প্ৰেজেন্ট অল কন্টিনিউ দি ইন্টাৰিম You are appearing on 17 and 22. It's just confusing orders because this submission were made in that matter.
There is no stay. Earlier stay was, my lord, they have not renewed, my lord, 2-3 times, they are absent also, that stay become vacated, my lord. Then last occasion, I prayed before the lordship, my lord, that this is the, no, there is no stay. Probably my landed friend cases stay. I think they are taking together, most probably it is reflected.
That is the defect.
In between, there is no stay, no continuation.
But now too it is continuing. I don't know rightly or wrongly, whatever
My lord,
cases
my
we
lord.
passed by
But
this
when
court.
stay is vacated, they are required to file petition, my lord.
But
Otherwise, it
vacation of
cannot be, my
order,
lord.
vacation of stay is also not there. Stay vacation order is specifically
But
vacation
this
of
is
stay
at-
order is also not there.
My lord, this is not interim order, at interim order, at interim order on the next returnable order. They have to renew, my lord.
Obviously, but there
But
is
if
no
it is
such,
interim order, my lord, no need, my lord. That's at
but
interim.
now
order,
it is
my lord.
continuing.
But anyway, it
So if you
does
say
not make
now
any
it is
difference, my lord. It
continuing
will hurt the
because,
matter, my lord.
yes,
Positively hurt the matter, no difference, my lord. Staying or not staying for 1 month, my lord. Already they have enjoyed 6 months.
6 months. So you have already enjoyed 6 months.
Lord, there is no
So
change of
22nd or 20, what was fixed?
My lord, 21, this is Tuesday, my lord, be better because this important matter, maybe most of the day it may skip also. my lord.
21st.
21st? Okay. List only matters on 21st. I will attempt to continue to go by tonight. 21st, 1, 2025. At the request made by your good name,
S. Nazneen, your lord.
S. Nadine, appearing on behalf of Jadala,
Yes, your lord.
wait for an adjournment. Prayer allowed for it, 21/1/2025. All the matters will be listed. Interim be continued till next date of listing. No problem.
No further prayer for my lord. No further prayer for adjournment, my lord, from the petitioner side, my lord. That may
Both the
be
parties are also hereby directed to proceed with the hearing without any further adjournment. Okay.
23.
Twenty-three.
Needs to be appointed.
23, amicus needs to be appointed, I think.
Daily bill.
Let us first appoint an amicus, thereafter we are going to admit, or isn't it? Mr. Ajay Bora, Ajay Bora, the learned council, learned additional PP. Post of decision jail appeals filed against the judgment and order passed by learned session judge Pokrajar in sessions case number 72 of 2022, whereby the present accused appellant is convicted convicted under section 498A IPC and no, sorry, 4 convicted under section 307/498A IPC and thereby sentenced to undergo RI for 1 year under section 498A IPC and to pay a fine of rupees 3,000 in default SI for 3 months and 7 years and also sentenced with 7 years RI for section 307 IPC and to pay a fine of rupees 5,000 in default SI for further 6 months. As the case is, as it is a jail appeal, the registry is hereby. I will select the name. Key name is written before signature to be done. MK Brown. Accordingly, MS MK Brown be appointed as an amicus to represent the appellant. Post of registry will do the needful. List the matter accordingly after 4 weeks.
24.
Yes.
Well, convicted under section 304, part 2.
304 part 2.
Yes, 8 years loss. And we lost
What
it.
is the conviction term of conviction? Sentence?
Sentence is 8 years.
8 years.
Now, my lord, acting mostly the petitioners, the appellant's wife was, my lord, eloped with the informant and neighbor, while adjacent house, both the person's house and houses are adjacent, lordship. The informant killed the petitioner's appellant's wife, lordship,
Then my lord lost FIR lordship. My lord, against my lord, the appellant lordship, earlier husband. This is the fact, my lord. Only two witnesses lordship. PW one, my lord, is the informant.
Whatever, we are going to issue notice and
Appeal may be admitted.
appeal will be admitted.
Yes. Hello, bail application is there, lordship.
It will be heard after issuance of notice only. Both the matters, we are going to issue notice.
This is to the NCR matter.
Yes. Heard Mr. M.H. Ahmed. Heard Mr. M.H. Ahmed, the learned counsel for the petition, appellant. Also heard Mr. R.G. Burwa, the learned additional PP appearing on behalf of state respondent. Makilihibu, this is an appeal, so and so, against the infringement judgment and order dated so and so. Passed by learned session just so and so. Convicting so and so Kodiva. Issue notice to the respondent. Number 2, no formal notice is required to be served on so and so. Also call for the LCA. Appeal is admitted. List accordingly after 4 weeks. Or if you devote, one I is there. I issue notice kori dibo. Issue notice kori dibo. I 1113 is 2024. Hard so and so issue notice. The you want to fix it after receipt of the LCA. Matter may be listed after receipt of the LCA. You may file written objection. Your verbal submission will also do let the LCA become and then.
My lord, the death may be given, lord. Otherwise, my lord, for 5 months, he is in jail, lord.
What to do? No, sorry, we don't cannot.
25.
Oh, my lord. Thank you.
May I please, my lord? This is a 482 application. In this particular case, there is an order earlier passed by the Honorable High Court to prefer a bail application, my lord. So we have preferred a bail application by way of an IA in this case. So today, my lord, I would like to praise the bail application first.
Why bail application in the form of IA?
In the form of IA, my lord.
Where is
Because
the order?
there is an order passed by the Honorable.
Yes,
High
where date?
Date, my lord, the previous one. It is passed by Honorable Justice Kalyan Rai Surana, I think.
In the criminal petition itself, the order was passed?
In the criminal petition, my lord. Yes, my lord. In the criminal petition, that order was passed.
Then your state is also there?
DRI.
Oh, DRI, sorry.
Yes, ma'am. Well, they need a protection. They are seeking for protection till their appearance before the court. Now, this case is under trial. 2 witnesses have been examined. Now, the thing is that there are 5 accused persons. Matter was split up and trial proceeded against one person. And the contraband recovered was ganja of 2004 kilos. It may be on compromise. So the thing is that my trial is also, there's a trial is also, we have to expedite the trial also. In trial, they are.
No, why? This is criminal petition is for quashing.
Yes, my lord, quashing.
This is a case of, commercial quantity.
No, it is a clear case of commercial quantity. My lord, may kindly come to page 20. I would like to give a brief.
No, it's okay. Now question is why bail is there, in fact?
The bail is here, my lord. There are 5 accused in this case. Now the prime accused and who, according to investigating agency, is the mastermind of this crime. That is the accused number 1, Gopal Chandra Rai.
But how bail can be entertained or separately this one? I don't know.
Because 438 application has been filed. Even by.
It can be rejected also, not granted. It can be rejected.
My lord.
It's not question of granting. It may be rejected also. I don't know what is the case.
My lord may at least take up the matter. My lord has a complete discretion to reject or accept.
So you want to press the IA first?
IA first, my lord. I get, my lord, there is no necessity for me to continuing with the 482 application. Because I need some protection, my lord. because my role is very limited, my lord. Even they would have agreed because some transaction has been made. I'm not the prime accused, nothing has been done, and no money has been transferred to the prime accused. It is, according to them, my lord, some money has been transferred to one Pandit traders and they handed over money to the prime accused who happened to be the Gopal Chandra Rai. That is my only complicity, my lord.
Now you have received the case diary and all? Have you received the case diary? Why scan copy is already charged in?
Yes, charging, but trial is
Charged
going on.
it, my lord.
Acha, trial, sorry, trial
Trial is going on.
Scan copy is there. Have you gone through the scan copy?
No, my lord, but I
Go
know the
through.
facts where,
Huh?
basically I know the fact that two witnesses have been examined till date. And the next date is fixed on. But 13th of this month, after 2 days, my lord, for evidence.
13th of this month.
Not this, after 2 days.
Get some relief, then I can face the trial along with the main accused.
Now you are in jail hazard now.
No, I am not in jail. I am not in jail. The main accused, my lord, I
This
kindly
is a subsequent, supplementary charge sheet.
But the basic fact is that during the course of investigation, DRI has issued summons to me under section 67. And I have not received that summon. If I received that summon, my lord, I would have definitely cooperated with the investigation. Thereafter, my lord, they have filed the complaint and made me one of the absconder in their complaint. And even the trial court.
Oh, you have been showing as absconder.
Absconder. And apart from that, my lord, while this complaint was filed before the trial court, instead of issuing the summon, they directly issue warrant of arrest against. That is wholly illegal, my lord. That is impermissible, and there are several judgments by the Honorable Apex Court that directly a trial court cannot issue the warrant of arrest once the complaint is filed. That is an illegality committed by the learned trial court.
Yes, Mr. Boro, what do you want to say?
But
Now he wants a protection only.
protection, man. So let him appear before the court, file a petition for bail, and till he appears, court may on that, but that the court will be, the trial court will decide as per law,
Yes, obviously.
as per law, because trial is also
And this
suffering,
criminal petition is also on that manner.
yes, only for that manner. And there are altogether 5 accused persons, and we took summons to them, and ultimately we have to split it up because the man is in behind the bars. Now we try to expedite.
For this
now-
person, you have to split it out.
Yeah, we split it up already, and then the charge.
No,
is
for
framed.
this petitioner or?
No, they are separate. Only one person was arrested.
Only one person was arrested.
He was the driver of the truck containing all the contraband ganja.
No, you split up the case for one person only.
Yeah, one person.
The remaining others all are absconded.
Absconded.
All are absconded.
Oh.
Now, if they later on appear, then again I have to summon all the witnesses like there. The trial will again go legally. So that's why let them appear before the court, and the court will file an application for the court, and court will decide as per law.
My lord, when someone was issued by the learned trial court, that I duly did receive. That particular warrant. It was my, it is in the same address, but I did not receive any notice under section 67 sent by the DRI. And that is their only grievance. And my lord, may just for my satisfaction, for once, my lord may kindly come to page 45. That will make the entire thing clear, my lord, in this case.
67 or IA or reading?
My lord.
IA or criminal
my
petition?
lord.
IA.
I.
Please?
45, my lord, page 45. Let me explain, my lord, what is my complicity in this case. Now, the prime accused, Gopal Chandra Rai, has received an amount of rupees 15,000 from one of the Pandit traders. And the investigation for the time being reveals that that particular 15,000 amount has been sent to that particular agent, Pandit traders, by me. Now, my lord, first of all, this particular transaction needs to have some kind of establishment by the investigating agency. My lord have found page number 45. Having come to know, they have issued a notice to the officers of Axis Bank to verification of this particular transaction. Now, my lord, may kindly come to para 33. I'm reading the last part. Accordingly, 29/12/2022, Axis Bank Guwahati has forwarded a reply of the above mentioned letter that without 15-digit number, name and address, PAN card, mobile number, bank cannot enable to search the above named transaction. Even that particular transaction has not been confirmed. And scan copy is already there, my lord. If your lordship look at the last part of the scan copies, there is no witness there is no official of Axis Bank has been made in this witness. Without making somebody witness in this case, how they are going to prove this transaction? That this is the 50,000 rupees that I have transferred to Pandit Traders, and accordingly Pandit Traders handed over that particular amount to prime accused Gopal Chandra Rai.
Pandit Traders.
Pandit Traders. Amount has been sent, according to them, amount has been sent to Pandit Traders. Thereafter, Pandit Traders make the payment to Gopal Chandra Rai, who is the accused number 1 and who is at present lingering in jail, my lord. Hello, I have only this much of complexity. Other than that, my lord, I have no involvement. Even during the case of investigation, my lord. It is a very long complaint. Around 70 pages complaint has been filed by the DRI, but nothing substantive has been come out against me. That is my whole case. So, my lord, I may be protected, my lord, so that I can appear before the trial court. I will face the trial. What is the difficulty?
Where is the last order filed by the court regarding issuance of NBW?
Regarding issuance of NBW, my lord, that my lord is available at main 482 petition. My lord, may kindly come to page 86 of the 482 petition. This is the first order. Order dated
86.
86, my lord.
Achha.
This is the first order by which non-bailable warrant has been issued against all the accused person who has been shown as an absconder in the complaint case, my lord. And thereafter, till I filed this case, my lord, the last order is 29/2023. No, my lord, may also come to page 90. And bail application has been moved on behalf of my lord, Gopal Chandra Rai. In that particular order, the case has been split up from the accused number 1 for the rest of the accused.
This is the order of split up order.
Yes. My lord, I am referring to order dated 18/7/2023 at page 90.
Yes.
My lord, may now directly come to page 92. Other part is not very material. At the last part, my lord, according that let the case against Liton Malakar, Kajal Malakar, Jhilik Ghosh, Subrata Devnath is split up by starting a supplementary case record and to continue with issuing of protection warrant. My lord, 2 witnesses have been examined, and I don't think that I have to do any cross-examination because they have stated nothing about the
Status security. Up to which date order is 12/9/2020. Put back it. This files. There are orders. Okay. As per this things on 5/8/2024 when PW1 was there. So it was asked for production of PW1 again on 19/8.
Well,
Oh,
initially,
sorry, 3/9/2024 his or her cross-examination.
Well,
That has already been completed,
yes,
PW1.
completed. I mean, initially what happened, my lord, that in this case, PW, the accused, who is Gopal Chandra Roy, who is now present, he was initially allowed to opt for LNDC. Then he said he will have his own counsel. Then this dispute come once or two occasions, the PW came and returned back. And subsequently, now they are appearing.
Now, as per your record, 2 PWs
Two
examined.
PWs examined.
The order of split up is passed on 18/7.
Yes, my lord.
You have to pass the order in IA. I
Aye, my lord.
to click order to. I mean 20, 25 or I no. Not Mr. A Roy. You are Mr. A Roy of B Decca. That's so. I Mr. B Decca, the learned counsel for the petitioner. And also have Mr. M.K. Boro, the learned standing counsel DRI. IA2. Now this is again under 482. I is also again 482.
Now, I is my lord under section 438. And the recent, I think 512 of the 512 of BNS, 520 of BNS.
Huh? And this interlocutory application has been filed in connection with criminal petition number 794 of 2024. In pursuant to order dated 13/9/2024. 13/9/2024. This is an application. The present application has been filed under section 438 CRPC for grant of anticipatory bail in connection with NDPS case number 35 of 2023 pending before the Court of Learned Additional Session Judge number 2, Kamrup M. Guwahati. The scan copy of the record has already been received. Stop, where is this? Next paragraph, it is submitted by Mr. Decca, the learned counsel for the petition, that during investigation, he never received any notice under section 67 NDPS Act from the investigating authority to appear before the to appear and to cooperate in the investigation. However, without receiving any notice by the present petitioner, the charge sheet has been filed by the investigating officer showing him as an absconder along with 3 others.
3 others.
3 others, along with 3 others. He further submitted that he is no way connected in the alleged offense, and only allegation brought against him is that he you send money.
My lord, this application has been filed for 2 accused, my lord.
This is for 2 accused.
2 accused, Jhilik Ghosh and Subrata Devnath.
But then who is to transfer the money? I mean,
My lord, that
your
even-
against you, the allegation is that you have transferred the money
Yes, my lord. Even that cannot be specifically ascertained by the DRI officer.
by whom?
By whom, my lord? But both are husband and wife, so they may accuse both of them. That is the reality.
Listen, both the petitioners are husband and wife, and the only allegation brought against these 2 petitioners is that they have transferred the money to one Pandit traders, to Pandit traders, wherefrom the accused Gopal Chandra Rai had received the money amounting to rupees 15,000. But surprisingly, from this seen that no witnesses of the Axis Bank has been made as a witness, and there is, and from the, you have submitted one note from the Axis Bank that
Yes, my
it
lord.
could not be where it is, page
Yes.
number.
Page number, my lord, just a moment. Just a moment, I have it. 45, 45, my lord, 43.
43.
No, not 43.
45 of I think.
45 of I.
Yes, 45 of I.
45. Yes, 45.
This is in fact the charge sheet.
Right.
This
Yeah,
is the charge sheet.
Yeah.
It is where it is not made with any persons from bank officials are not made witness in the case, and it is also a seen from the charge sheet that without any proper digit account number, comma, name, address, and PAN number, etc., the bank is not in a position to search the above mentioned transaction. In spite of such a report from the bank authority, the case has been charged against the present two petitioners, showing them as an absconder with the allegation that they involved in the transaction of money. They involved in the transaction of money to the main accused Gopal Chandra Rai. However, both the accused petitioners are ready and willing to cooperate ready and willing to appear before the learned trial court below in each and every date fixed by the learned trial court below, if some kind of protection is given to the present petitioners. Next para. Mr. Deka further submitted that the learned trial court below had issued NBWA on the first day of receipt of the charge sheet, that is on 16/3/2023, without even issuing any summons to the present petitioners and without complying the guideline provided by the learned Honorable Apex Court. Further, on 18/7/2023, the matter was split up. The case was splitted up, and by issuing the production warrant against the present two petitioners along with two others. Next para. Mr. Boro, the learned standing counsel, DRS submitted in this regard that what is your submission? In fact, two witnesses are Mr. Boro. Two witnesses are examined. That is true. Otherwise, what is your stand?
The thing is that it's not about the money of 15,000 rupees only. It's not that the first day there's a warrant is an issue. They have violated two summons for the department. They were initially summoned after all these things came up, but they don't turn up. Now they're saying that they have not received it. Now that tracking ID has not been closed with the final complaint. That's the thing which I have to say. But apparently, from the statement of records, whatever say, there's a huge transaction between in the petitioner's account. And petitioners.
Not a case that only 15,000 was.
It's not a further, that other amounts are also there, but from different parts of the country and the northeastern states. So only from Guwahati or anything for Tripura, Dibrugarh, like that. So these transactions are in huge amount. That's why they are summoned, they have not appeared. The thing is that if they don't appear, they will remain absconding. So for the purpose of trial, they must appear. So it's very difficult for me to now say that to reject it. If we reject, they will not come. And if they appear, then I think the entire case can bring up to the logical conclusion. Because two witnesses have been done. And if they somewhere arrested after a delay of 1 or 2 years, then that thing again will be repeated. Same thing happened with them. So that's the issue there. Otherwise, if they appear before the court and they file an application, the court will decide their court as per law.
Mr. Bose submitted that it is not a case that the something that the department had already issued two summons oblique notice in two occasions, but they intentionally intentionally did not appear before the investigating agency at the time of investigation. Further, he submitted that it is not a case wherein only 15,000, only rupees 50,000 was an transaction, but there are several other transactions between the accused petitioners and the main accused via
No,
state
no,
company.
it's not a main accused, from unknown sources. The
Okay.
money has flowed into the account from unknown sources in we use quantity like 1 lakh, 2 lakh, or 90,000 like that in very different
In
dates.
an account of whose this may.
This Anjali Ghosh. The
Huh?
entire statement is there, the accused person.
These accused persons,
Yeah, the present petitioners.
the account of the present petition.
Yeah.
Not only case of that only 15,000 rupees, 15,000 was under transaction, but several other amounts were already transferred to the account of these two accused petitioners from unknown sources. But it is also admitted fact that if the two accused petitioners, but it is also admitted fact that as both the accused petitioners are shown as an absconder, they may be directed to appear before the learned trial court below with an appropriate application for bail, so that the trial may be proceeded against these two accused petitioners. Next paragraph. Considering the interest submission made by the learned counsel for both sides and considering all relevant factors, this court is of opinion that these two petitioners may be, accordingly, these two petitioners, number so and so, is hereby directed to appear before the learned special judge.
No, madam, it's
Number 2, na?
number 2.
Special judge number 2, Kamrup M. Guwahati, with an appropriate application for bail, which may be considered in accordance with law. When next date is fixed, can you tell us the next date?
My lord, next date is on 13, but it is a too short a time, my lord. They will come from West Bengal. And these people are not economically.
1-3.
Yes, madam,
13th.
1-3. So my lord,
15 days will
10 days
do?
time may be allowed.
Huh?
15 days time may be allowed.
15 days?
15 days.
Within 15 days. Okay, we are allowing 15 days. Within
Deeply
15 days, we allow.
Yes, my lord.
In that case, both the matters will be disposed of, I think.
Yes, my lord.
Because nothing remains in other
Yes, my lord.
criminal matters.
Both the matter can be disposed of.
I would order to Koribo. I would order to corruption in view of order passed in I criminal so and so. The present petition is accordingly disposed of.
My
Is
lord,
there any?
Till then I may be protected.
Yes, you will be protected.
Yes.
Your NBWA issued will be stayed, public
Yes.
suspended.
Deeply obliged, my lord.
Both the matters are suspended.
26.
Eight is allowed.
Yes.
528 application of the BNSS for setting aside the impugned order at page page 22, Lordship.
Case diary, you have
Where-
received?
page-
Case diary?
Directed to get a report from the IO regarding Chilpa on the material. So that report we do not have access to. Only the case diary.
Lordship,
Oh, right, or it was ordered on 21st of October, I think.
In 1411 also.
14/11 also.
Lordship. May I refer?
But that is the order for seized articles.
Yes.
Yes.
But that report is not, that is erratic.
Now, what is your submission where you want that report or?
Lordship, 10 days can be given.
Lordship, may I refer? I highly object this prayer, Lordship. May I refer?
No, no,
page
this question
12,
is that
Lordship.
objection,
Yes.
yeah, just wait. Objection could have been made before the court while passing the order. That time you remain silent and order is there that to call for a report. Now at this stage, objection, I don't know what is the objection or if there is, now this is the observation of the court itself.
Yes, yes.
Not from any, I don't think there is any submission from the court, but here is only the call for the report from the investigator regarding the ownership.
Yes.
That is the observation of the court itself.
Lordship, may kindly look into page 12.
No,
Fair
just
Lordship.
wait. page 12, I'll look into, but the question is that that's why I'm asking the additional PP that in absence of that report, if it can be proceeded, I'm going to hear. Otherwise, it will be a list. That's
My respectful submission, Lordship, this page 12 will justify whether this.
now
should be
see,
required or not.
this is not justification for me. This is the observation of the court or the coordinate bench that the report is required. It is not my observation, it is the observation of the coordinate bench that is required. That's why I'm just asking you, even in spite of that absence of that report, when if it can be proceeded, it can be proceeded. That is up to the additional PP. That is it.
Time may be given so that we can furnish. That's one solution.
Otherwise, this petition is for quashing of the FIR.
That is why I'm referring page 12. Just for a moment, for because this affair has been lost in the year 2023. Lordship, I'm referring the particular point. What was the affair, Lordship? I, the undersigned, have to have have the honor to draw your attention to the fact that some mischievous report has been found in the Facebook and Twitter since almost last 3 months, targeting Lamding MLA Sibu Misra. Report is totally baseless, but regular highlighting of such devious comments may create mistrust and misunderstanding in our society. In on preliminary inquiry, it is learned that the account claims to be a residence of Lamding, but there is no record to claim that such a person resides or even resided in Lamding. Therefore, it can perhaps be inferred that he is fake. His Twitter ID account in the name of Sanjay Burwa, alias so-and-so, Facebook profile ID so-and-so, and Instagram. And this petitioner is a president of Lordship AGP, Assam Gana Parishad. He's the Anchalik president of Lamding, and he is solely from Lamding. I'm referring.
What is the actually the scissor goods?
No,
Scissor
that's
goods?
the computers and some
All
electronic
my Lordship.
Mobile Lordship, mobile handset.
No, not only mobile, everything, all
Computers,
gadgets
all
from
of
my
it.
house.
Electronic
house.
gadgets.
All the electronic gadgets from my house has been picked up by the police. I have given the list, Lordship. Because of the continuous seizure, Lordship, my wife, I have to drop my business. I have a business of Gayatri Motors, Honda two-wheeler business that had to drop because all the gadgets have
So
been.
for those seized items, have you applied for any Jimma?
Lordship, that is page 22. It's been rejected a year ago, 23/11/2023, Lordship.
Oh no, this is the
Page
what
22.
kind of petition? This is for Jimma petition.
Jimma petition for setting aside that order, Lordship.
Oh, that order. Okay.
Yes,
Okay.
Lordship.
Okay.
Lordship may kindly.
But then obviously ownership will be required, I think. Report will be required then. I thought it is otherwise.
No.
Yes, but it is purposely, Lordship. We do not know. The IU is not furnishing the report, Lordship.
How can we proceed that? Report is required, no? How many days you want?
Where did it come, Lordship? My entire business is.
See, we don't have any
Yes, that's
days
why
the next week.
That's why I'm praying for 10 days time. Actually.
Lordship, it will be very, because
Already
my
planned.
business has
I
been
have
shut down
already-
because of these
We don't
activities.
have any days.
Yes,
We don't have.
then immediately after reopening on 6th Lordship.
Can I get business is the point for it.
Photo time, yeah, no, more than 3 days.
Just tell Lordship, it will take few minutes. If they place at
It
least
will
let
take
them
few
place
minutes. We'll have to pass the order, no?
Lordship.
The report I have the detail. Report not yet received.
Any day prior to vacation, Lordship.
Matter. We don't have any date to prior to vacation. What to do?
Any day
19
prior
and
to
20 excessively, and we are going
Any
out.
day, Lordship.
They are
It
going
will-
out. We don't have
It
any.
will hardly take.
Minutes is different. কি করব? Huh?
Then,
Immediately after vacation, 6th.
or can it be on 3rd, Lordship?
Third, not possible. 6th. 6th.
But this time, Lordship, let them positively furnish the report.
Yes, obviously you try, you personally intimate. At a লিখি দিয়ক, the learned additional PP will personally make communication with the
Yes.
concerned IU to get the report. Okay.
Positively, Lordship.
Yes.
Obliged, Lordship.
49 of the supplementary list.
20,
49.
49.
Made please, Lordship.
Ah, yes.
This is a quashing petition, Lordship.
Other side is there.
Lordship, other side mentioned it, Lordship, so this is, has been listed. It's a by order matter.
Okay.
It's a 482 application, Lordship. In this case, what happened, Lordship, 133 proceeding was initiated against the petitioners, Lordship. In that case, there is an order given directing the petitioners to remove that obstruction, Lordship. We have filed one revisional court from the very, on the very first day, state the order, and thereafter finally disposed of, directing that you go to the executive magistrate court and file your reply there. At that situation, Lordship, we came to High Court, praying for setting aside of Lordship that entire proceeding, quashing of the entire proceeding under section 482. As because, Lordship, the dispute is in regard to that property is in civil in nature, and already title suit is pending between both the parties. And at that point of time, 133 proceeding was initiated.
When the 133 proceeding was initiated, at the time status was already pending.
Yes, Lordship.
Then during the pendency of the title suit, 133 was there.
Yes, yes, Lordship. Title suit pays, Lordship, Annexure 1 pays 14, the plaint which was filed by them, Lordship. Page 15, your Lordship will find the name of Mohammad Anwaruddin Borbhuiya and Musammat Anwara Begum Borbhuiya, defendant number 1 and 2. The present petitioner, Lordship.
Did that title suit was filed by you or?
No, Lordship, by
They,
them.
by them.
By them, Lordship, including some other person also, Lordship. It was filed on, Lordship, 26th day of October 2022. Page 20, your Lordship will find their stand taken by them. Para 9, 10, 11, I will read, Lordship. That the predecessor of the plaintiff number 5, Thambal Manipurni, wife of late Amu Singha, was the owner in possession of 15 Katha 11 Chetak 14 Gonda 1 Kora land in CS Patta number so, died leaving behind his only son Bakul Singha. Accordingly, his name is mutated as Pattada number 15 of RS Patta number so, who died leaving behind his two daughters, namely Koyanima Manipurni and Imamocha Manipurni as his only legal heirs and successors, and share of each daughter was 7 Katha 13 Chatak, 17 Gonda, 1 Kranti land, and Konyama Manipurni died leaving behind her only son Nadia Singha. So her entire share of land devolved in favor of Nadia Singha, and accordingly his name was mutated by mutation serial number 36. In second arrest period, second arrest Patta number 8 was issued in his name as Pattada number 12 and died leaving behind plaintiff number 5 and pro forma defendant number 21 as his only legal heirs and successors, and accordingly they have been possessing the said land in Azmali by paying land revenue to the government of Assam, which is included in Schedule 1 land of the plaint within Schedule 1 land below. The predecessor of the defendant numbers 3 to 13, Hari Singha, Nithu Singha, and Bol Singha, sons of late Paira Singha, being mutation serial number so, had right, title, and interest in respect of 1 Katha 15 Chatak 9 Gonda 1 Kora land, died leaving behind principal defendant number 3 to 13 as their only legal heir and successor as per Hindu Succession Act. Accordingly, they jointly inherited 1 Katha 15 Chatak 9 Ganda 1 Kora land in second arrest Patta number 8 of Dag number 17, 29, 30, 28 of Moja, Tarapur, Part 3, Pargana, Barakpur. that during the time of separate the land of Rajendra Singh and others, amicably all the pattadars of second RS patta number so and so hold a meeting in 17 years back and amicably decided to construct a private path in the eastern and southern side of the land of Rajendra Singh from Shasta Ghat up to Panchayat, Shoshan Ghat up to Panchayat Road, measuring north-south 15 feet broad and 280 feet long. So according Lordship, for that portion I am reading, so accordingly they pleaded that they amicably, Lordship, constructed a private path. It is their case, Lordship. And later on they have, how we have disturbed in the path, it is mentioned in para 12, Lordship. That in the last part of January 2022, that is on 28/1/2022, plaintiffs found that defendant numbers 1 and 2 entering into the Schedule 2 land below, which is a part of Schedule 1 land described below, started to fell earth over the Schedule 2 land and a part of Schedule 3 path. Plaintiffs asked them to vacate the same as the land belonged to them and path is Asmali path and nobody can create any obstruction in the Asmali path, but the defendant numbers 1 and 2 did not respond favorably but replied that they purchased the property from predecessor of defendant numbers 3 to 7 and defendant number 8 to 13. So Lordship, this is our purchase property from defendant numbers 3 to 7 and defendant numbers 8 to 13 by a registered sale deed, Lordship. It is subsequently also mentioned in the later part of this para, Lordship, page 21. Second line, Lordship. Thereafter, plaintiff searched in the office. Searched in the office of Senior Sub-Registrar Silchar, and on searching the plaintiffs found that predecessor of defendants number 3 to 7 and defendant numbers 8 to 13 sold out land measuring 1 bigger land in the suit patta within specific boundary by a registered deed of sale by deed number 2404 of 2012 executed on 29/9/2012, much before 2022. There are cases that in the year 2022 we have started, Lordship, disturbing, but our deed is dated 29/9/2022 and since 2012 we are possessing that land, Lordship, by constructing houses. And registered on 30/9/2012, 1/10/2012 in the office of Senior Sub-Registrar Silchar in favor of defendant numbers 1 and 2. Plaintiffs obtained a certified copy of the registered sale deed so-and-so and on perusal of the aforesaid certified copy of sale deed so-and-so, first came to know that the predecessor of defendant numbers 3 to 7 and defendant numbers 8 to 13, without having any right title interest of 1 bigger land in Dag number so-and-so of second RS patta number so-and-so, without exclusive possession over 1 bigger land of the Schedule 4 below, fraudulently, illegally in collusion with defendant numbers 1 and 2, manufactured, void, illegal, fraudulent, collusive, inoperative deed with defendant numbers 1 and 2, as well as said deed dated 29/9/2012 and registered on so-and-so. So their basic allegation is that, Lordship, fraudulently we have created a sale deed in the year 2012. So with this, Lordship, they are in para 13, they have also injunction prayer, Lordship. I will not read the entire readings, Lordship, only some part I will read for the better adjudication of the matter, Lordship. Para 13, your Lordship will find from the bottom 8th line, if urgent and immediate order of injunction. Para 13, last 8th line. If urgent and immediate order of injunction is not passed, then the inherited right the interest of the plaintiff and performer defendant in respect of Schedule 2 land, Schedule 3 path will be seriously affected, resulting multiplicity of suits and proceedings causing irreparable loss and injury to plaintiffs and pro forma defendant numbers 14 to 59. So it is a fit case for passing urgent and immediate order of injunction as prayed for by plaintiffs for restraining principal defendant numbers 1 and 2 and their laborer, employees and all persons claiming through them that dispensing with notice under required under Order 39, Rule 3A CPC. So, Lordship, the plaint was filed along with injunction petition. prayer to cancel my sale date, Lordship. That is one of the prayer in the plaint itself, Lordship. And for permanent and temporary injunction, restraining the principal defendant numbers 1 and 2. Page 23, your Lordship will find the prayers, Lordship. Prayer D is for cancellation of the sale deed and prayer F is for injunction. Accordingly, after receipt of notice, we filed our written statement, Annexure 2, page 27. We have mentioned about our purchase deed, and it is reflected from the pleadings of the plaint also that they are aware about our sale deed, Lordship. We have filed our written statement March 2023. During pendency of this title suit, Lordship, page 42, Annexure 3, that is the 133 proceeding, Lordship. Same, all the sale deed and everything was pleaded there also, Lordship. Prayer portion, page 50 and 51, Lordship. 50, under the circumstances stated above, it is prayed that your honor would be graciously pleased to draw up proceeding under section 145 CRPC in respect of schedule 3 land and under section 133 CRPC in respect of schedule 2 private park by restraining the second parties and their men laborers from entering into the schedule 3 property and disturb such peaceful possession of the first party or not to dig or fell earth or making any construction by attaching the schedule 3 property under section 146(1) CRPC to protect the interest of the first party and Pakradar of second RS Patta number A, right, fully entitled to enjoy the possession of the below schedule 3 land thereof and to make any inquiry as to the actual and factual possession of the below schedule 1, 2, 3 land, allowing the petitioner to adduce evidence in support of the claim and declare the Asmali possession of the first party and also kindly drew up a proceeding under 133 CRPC. Lordship, entire pleadings are similar to the pleadings of the plaint, Lordship. Irrespective of that fact, Lordship, the Annexure 4, page 56, the learned executive magistrate has drawn up a proceeding. 19/1/2023. Case record is taken up on transfer in my file. Peruse the petition along with police report filed by one Bira Singh, representative secretary Sri Samiran Chandra Dhar, so and so. Both are the Tarapur Part 3, Tarapur Part 4 respectively, PS Silchar District, Kachar, Assam, against Anwar Uddin Borbhuiya and Musammat Anwara Begum Borbhuiya, heard the learned lawyer for the first party at length. On perusal of police report and on hearing the submission made by the learned lawyer for the first party, it appears that the second party along with others have unlawfully blocked a public path as a result, the first party members suffer badly and thus there is arisen an apprehension of breach of peace and public tranquility between the both community in the locality. From the above, I am satisfied that second party
Just
have
tell us one thing, whether pending during dependency of before filing of this petition for 145 or 23 proceeding, was there any order of injunction?
Lordship,
Because there is a prayer for injunction. The
Lordship.
permanent injunction was temporary injunction was prayer for temporary injunction was there
Whether
also.
this case was filed or not, maybe my learned friend will be aware. I have taken the plain.
Prayer for permanent injunction was there. Was there
Obviously,
any
there will
temporary
be-
injunction, prayer for temporary injunction?
Obviously, there should be a.
Obvious
it
is okay
Lordship,
then.
that I have not enclosed, Lordship. But there are some judgments of Supreme Court and other high courts. It says, even our high court says, when there is a civil case pending, 133 proceeding cannot be
On
initiated.
that apart, I'm asking you because prayer for 133 or 145, whatever there, that could have been made before the
The
trial
trial
court
court.
under 39 1 and 2.
Yes, Lordship.
That is that's why I'm
That is one of my ground, Lordship. Whether without any injunction prayer or without, if there is an injunction prayer, that 133 will go, Lordship. And without going for an injunction prayer in their title suit, how 133 can be filed? And Lordship, we aware that when we filed a title suit, 145 normally goes, Lordship. It should be kept in abeyance till the decision of the title suit, Lordship.
Okay, then. Then 56, the proceeding was drawn up.
Yes, Lordship. In the event of any objection, the second party to show cause as to why this order should not be made as an absolute on the date fixed. So next date was fixed 15/2/2023. Before that, therefore, I am satisfied to draw up a proceeding under section 133 CRPC and pass a conditional order directing the concerned police station Silchar to remove the obstruction from the path by the second party over the below schedule mentioned land within 7 days. So without hearing us, without Lordship, it is reflected that upon a police report, Lordship. So accordingly, Lordship, that order was passed. Police report also I have enclosed, page 57. Thereafter, Lordship, criminal revision we have filed before the session judge under 397. On the very first day, the entire order was stayed, Lordship. Page 66. Same, the operation of the impugned order dated 19/1/2023 passed in case number 42 shall remain stayed till disposal of this revision petition. And later on, Lordship, this revision petition was dismissed. Page 72, paragraph 16.
'73.
Yes, Lordship. Page 72, paragraph 16, Lordship. Some provisions were discussed and thereafter a direction was passed. In view of the above provision of law, the revision is required to approach before the court below and take part in the proceeding as per the above law. In the result, the revision stands dismissed. However, without cost, the impugned order dated 19/1/2023 passed by the learned ADM Kachar Silchar in case number 42 M 2023 under section 133 of the CRPC is hereby affirmed. However, the revisionist is directed to approach before the court below and take part in the proceedings. I have asked him to search whether is there any injunction order. Attention from operators. I have challenged thereafter again, Lordship, Annexure 8, page 74. After disposal of revision petition, another order was passed on 30/10/2023. CR put up on a judgment dated 6/10/23 White Criminal Revision number 17 of 2023 passed by the Court of Honorable Additional Session Judge FTC Kachar Silchar. The said Honorable Court in its judgment has affirmed the order dated 19/1/23 passed by this court under section 133 CRPC and further directed the revisionist to approach before this court and take part in the proceeding. Also seen the petition dated 30/10/2023 submitted by the first party. They submitted a petition, Lordship. From the above and on perusal of the CR, I am satisfied to direct the second party to remove the obstruction created by the second party over the schedule mentioned path within 3 days from the date of receipt of copy of this order or show cause as to why the order dated 19/1/23 should not be made as an absolute on the next date fixed. Local police is directed to execute the order immediately and maintain peace in the locality. So, Lordship, this order was passed fixing 8/11/2023. In the meantime, we have approached this court. Accordingly, this court, while issuing notice, order dated 30/10 stayed. That order was stayed. Thereafter, again on 14/11/23, we have filed one IA, that is IA criminal 1094. Of the order dated 8/11/2023.
Another order was passed on 8/11.
Yes, Lordship. So till then, Lordship, three orders were already passed, 19/1/23, then 30/10/23, and 8/11/23. All the orders were stayed by this court. Subsequently, the first order and the last order was already also stayed on 14/11 in the IA, Lordship. My point of argument is that, Lordship, if title suit is pending, they ought to have take injunction order from the civil court. Not showing any link with Lordship, only title suit. So my point is that, Lordship, they ought to have filed an injunction before the learned trial court. Without doing that, Lordship, they filed 133 proceeding, 145 proceeding, which is not tenable in the eye of lawyers because there is the same dispute, civil suit is pending, Lordship. And moreover, this is not a public path, Lordship. This is our private property, purchased property, and it's a patta land, Lordship. Their petition itself, they have mentioned it as private path, Lordship. Page 52, your Lordship will find. Page 52, that is the prayer portion of the 133 proceeding, Lordship. Over the schedule to mention private part forthwith. Lordship, how section 130 will be applicable in a private path? That was not taken into consideration by the magistrate. So my argument is that, Lordship, it ought to have filed a injunction that was not done, and I am also not aware about that, whether any injunction order was passed or not, Lordship. In this case, I am relying on some judgments. Already at the time of issuing notice, I have submitted our High Court's judgment 2008 1 GLR page 254, Shankar Saha. One judgment, maybe it is in the file, Lordship, and one Giridhari Lal and others.
We have here that I don't know, one Sarala Begum, one Dalim Hussain. Oh, these are filed by the respondent. Yes, you are relying, yes.
I have already submitted Shankar Saha, Honorable Justice B.K. Sharma sir judgment.
Shankar Saha is also here.
And one Giridhari Lal and others,
Girdhari Lal.
Jammu and Kashmir High Court.
Girdhari Lal, yes, it's here only.
Yes.
Girdhari Lal is also here. And Shankar Saha is there, and from the respondent side, three judgments.
I am relying, Lordship, that is Mitesh Kumar J. Shah, the Supreme Court judgment, Lordship. And Bhajan Lal was relying by this judgment. So, Lordship, Bhajan Lal also I am relying. In Shankar Saha, your lordship will find para 24 and 29. First of all, lordship, Shankar Saha, para 24 and 29. It is our High Court judgment, Lord.
Yes.
If a dispute is of civil nature, such dispute cannot be entertained by a magistrate under section 133 CRPC. The provision of the section can be used only for settlement of dispute in relation to public right in the general interest of public at large. Unless a nuisance is created at a public place, section 133 does not apply and no order can be passed under this section, as has been held by this court in Bhabakanta versus Ramachandra reported in so-and-so. When the obstruction did not cause public nuisance or the alleged conduct did not affect public right, the magistrate has no jurisdiction to continue the proceeding under section 133 CRPC. For the applicability of section 133 CRPC, the public must have a right of way which is being obstructed or on which nuisance is made, or it must be a public place where the alleged obstruction is created. The ingredients of section 133 CRPC imply not only that the way, river, or channel must be one of public use, but the obstruction must be to that of public use. Thereafter, discussing about the case, lordship, in para 29. From the aforesaid discussions made on the basis of the materials on record, I have no hesitation to hold that the SDM proceeded with the matter with gross irregularity and illegality, giving a complete goodbye to the mandatory requirement and procedure envisaged under section 133 CRPC. This being the position both on facts as well as on law, the entire proceeding in case number so-and-so is liable to be set aside and quashed, which I accordingly do. So accordingly, that proceeding was set aside, lordship. In para 25-26, your lordship will find some other judgments were also discussed in this case, lordship. Then Giridhari Lal, para 10 and 11.
Yes.
From bare perusal of this order, it appears that except bold abatements of encroachment in Ballol Nalla, there is no substantial evidence with regard to satisfaction of magistrate in passing the order. No khasra number of land and other identification of land has been mentioned. From perusal of various sale deeds dated so-and-so, it is evident that petitioners have purchased land measuring 5 canals under khasra number so-and-so. So-and-so, mutation of land has been attested in favor of petitioners. Civil litigation between Union of Indian petitioners are pending with regard to same land in a suit filed by petitioners on so-and-so, directed the Tehsildar settlement for demarcation of land. Tehsildar accordingly filed report on so-and-so. After perusing report on so-and-so, has restrained the Union of India Deputy Commissioner ACR and Tehsildar from interfering into construction work of raising a boundary wall by the petitioners over the land. Now, instead of filing written statements before civil court, the district magistrate, who is also a party in civil suit at the behest of Army Union of India, has passed the impugned order. In this way, order impugned is full of malafide. No date has been fixed for appearance of aggrieved party or parties to file objection. The procedural compliance of Chapter 10 of CRPC has totally been bypassed by district magistrate. Here also no reply or objection has been filed. I am of considered view that district magistrate has passed the order on the saying of Commander Armed Brigade so-and-so without knowing the procedure for passing of such order. And thereafter, lordship, in Messrs. Shiraz Cinema versus Srinagar Municipal so-and-so, the Jammu and Kashmir High Court has held that Section 133 CRPC provides for the removal of public nuisance. The purpose and object of Section 133 CRPC is not intended to settle private disputes, between two members of the public, but is intended to protect the public as a whole against the inconvenience of public nuisance. No doubt that the provisions of section 133 CRPC cannot be used for settlement of disputes between private parties. Similar to our case, Lordship. In our case also, there is a private dispute going on by way of a title suit, Lordship. And that cause of action was brought in the nature of 133, which cannot be. And now 2002, 1 SCC, page 241.
2000.
2002, 1 SCC. No,
No,
Lordship,
no,
no,
you're not.
Lordship, that is Lordship 2021-0 Supreme Mitesh Kumar Jha.
Yes.
Mitesh Kumar J. Shah.
Relying on paragraph 27.
Yes, Lordship. 37, Lordship. Although there is perhaps not even an iota of doubt that a singular factual premise can give rise to a dispute which is both of a civil as well as criminal nature, each of which could be pursued regardless of the other. In the instant case, the actual question which requires consideration is not whether a criminal case could be pursued in the presence of a civil suit, but whether the relevant ingredients for a criminal case are even prima facie made out. So it relied that both the proceedings can collaterally go, Lordship. There is no dispute. But whether the civil dispute which is going on in between both the parties can be given a color of criminal offense, Lordship. That was discussed. Relying on the facts as discussed in previous paragraphs, clearly no cause and case regarding a criminal breach of trust or cheating is made out. The dispute between the parties could at best be termed as one involving a mere breach of contract. Now, whether and what is the difference between a mere breach of contract and offense of cheating has been discussed in the ensuing paragraphs. Whether the sale of excess flats, even if made, amounts to mere breach of contract. These are discussed. Whether the dispute is one of entirely civil nature and therefore liable to be quashed. That part will come, Lordship. Para 41. After relying on different judgments, Lordship, in para 45, it held that applying this dictum to the instant factual matrix, it can be safely concluded that the present case clearly falls within the ambit of first, third, and fifth category of the 7 categories enlisted in the above said judgment. The case therefore warrants intervention by this court, and the High Court has erred in dismissing the petition filed by the appellants under section 482 CRPC. We find that there has been attempt to stretch the contours of a civil dispute and thereby essentially impart a criminal color to it. Bhajanlal was relied on, Lordship. Paragraph 44, Bhajanlal, all the procedures and all the guidelines were mentioned, Lordship. And thereafter, on the basis of that guidelines, Lordship, 105th, the entire proceeding was closed, Lordship. So I leave it to your Lordship, Lordship. This is my understanding.
Page 56 now. The order passed by the trial magistrate is a conditional order. They choose, he issued notice, they chooses not to appear. They went straightly to the session judge court. But the session judge court held object. Page 71. Paragraph 14, Lordship. The impugn order appeared to be a conditional order calling upon the revisionist to show cause as to why that order cannot be made absolute. If the revisionist had any objection in respect of the order, he ought to have approached before the court below and could have denied the public right, and the court would have approved the following procedure. Now, the procedure has been laid down under 137. He could have very much availed that opportunity, but why that process of the trial magistrate should be scuttled at this stage? What prevented him to go there and satisfy the court below? It's only a conditional order. And in that regard, Lordship, that is what the direction has been given in paragraph 16, that he should approach the court. In similar line, Lordship, that Lordship, Dalim Hussain case has been disposed of. Paragraph 8, Lordship. Paragraph 8. Dalim Hussain Majumdar versus State of Assam.
Yes.
Paragraph 8, Lordship. The order dated 9/9/2022 passed by the Land Executive Magistrate is based purely on a police report, and the said order was passed because of emergency. The respondent were given the opportunity to appear and to contest the said proceeding, but they did not do so and filed a revision petition instead. This court is of the opinion that the order dated so and so passed by the executive is an interlocutory order. Same is there, Lordship. It's an interlocutory order. Order passed in the basis of police report and because of an emergency. Therefore, the order dated so and so is an interlocutory order and no revision lies against such order. The non additional should be the FTS directly itself by taking this and so. So it's an interlocutory order. Let them approach the court. They have chooses without finding any objection. The next is the case, Lordship, this Sarla Begum case. And I'm relying on paragraph number 11. In fact, Lordship, in the Dalim Hussain, my friend appeared in that case for the private
So far, I
respondent.
remember that case I was appearing. Facts are different, Lordship. I was.
But
I'm
it was
thinking of
against
giving
it was
reply,
against
Lordship.
an interlocutory order.
That in that case, I argued that it is not interlocutory order. This is an intermediary order, Lordship. If any order gives affected any right of the
Right.
parties, that is intermediary order. That was Lordship argued in that case. And there was, so far I remember, there was no civil suit is pending.
Now you are relying on another judgment is?
Paragraph 11, Lordship.
Which judgment?
Sarla Begum.
Sarla Begum.
May I read, Lordship? Now, the facts to be noted that although the observation of the Lund Revisional Court may be correct, but provision of section 146(1) CFC provides that such an order takes the shape of an interlocutory one, as the same can be vacated by the trial court. An attachment order can be withdrawn even when the magistrate is satisfied. In view of that matter, the other side respondent to whom notice was issued was in position to assail such an order of attachment, and the Lund trial court, after hearing the parties, was in a position to vacate such order. In view of provision, no revision lies against an interlocutory. So here in this case, they could have very much availed that opportunity where approach the court below, only notice has been issued and that was only a conditional order. Why they should have scuttled all those process and the judicial process should be scuttled and the trial magistrate should be denied of that opportunity. If they have reversed the provision of 137, which gives them all the provisions that they could approach the court below, file their objection, the trial magistrate will modify that order. The lastly, Lordship, is 1985 1 GLR, page 223. I am relying on this point of that even if the civil proceeding is pending, of course, it's a different civil proceeding is a declaration of Azmali, not only that, and the set aside the sale deed and declaration of Azmali right over the other, there was other pattadar of that. There is more than, there are only 2 petitioners, there are only 6 plaintiff, Lordship. The relevant paragraph is paragraph 7, Lordship. As the criminal court is not concerned with the right of either of the parties regarding possession of the disputed land, and the object of the proceeding under 145 being prevention of breach of peace arising out of possession of land or water, it was stated in Chakrapani versus so and so. The pendency of civil court regarding the same property is no bar to take action under 145. It has however recognized that the position would be different if civil court had put the property in custodial legacy. So since there is no any order from the trial court in civil court, Lordship, there is no bar exercising. That is what has been stated here. So in my respecting submission, Lordship, let them approach the trial board and get them file their objection and get that vacated. What should that should be scuttled, Lordship. And moreover, in the guise of 482, there is more or less a second revision. One revision they have already availed.
My reply is that, Lordship, in that case, that is a revision, Lordship, and no 482 was there maybe. So far I remember, I forgot the Dalim Hussain case, but Lord, the facts are different. There was no civil dispute on the same facts and pleadings, Lordship. Here in this case, same prayers are in the plaint also, Lordship. And they are trying to take recourse of the same prayers before the 133 proceeding also, Lordship. And in the 133 proceeding itself, in the petition itself, they have mentioned that it's a private path, Lordship. So whether private path will come under the purview of section 133. On that ground, I am asking for quashing of that entire proceeding. And if the proceeding is illegal, why should I go and appear before that court, Lordship? If it is illegal, Lordship, he is illegally exercising his jurisdiction. This High Court has ample power to set aside that. And it is clearly mentioned in Bhajanlal and the 2021 decision also. If the dispute is in civil in nature, the cannot be given color of a criminal nature offense, Lordship. 133 itself says, Lordship, that any harmful obstruction or nuisance should be removed from any public place or from any way, river, channel. Where is that? There is a question of private path is included in 133.
No, he is saying that this is Azam Ali.
No, the
Prayer is
prayer,
also there, prayer is also there, Lordship, in the plaint.
Schedule 3 is in respect to the path which they are releasing that this is a path and I am obstructing.
Page 22, Lordship. Prayer B, Lordship.
The purchase land, Miadi land, how a public path can be created over a Miadi land.
No, that is your claim, that is the purchase land, but their claim is that it is on the basis of some fraudulent sale deed,
Lordship, that will. be
you
decided
claiming
in
your
better
right
case.
over the land.
No, Lordship, their case is that on the basis of a fraudulent sale deed in the year 2012. And since 2012, we are residing there, Lordship, by constructing houses. Suddenly in the year 2022, they are saying that this is a public path, Lordship. And now they are saying it's a public path, but in their petition itself, they are saying it's a private path, Lordship. In plaint also, they have mentioned that they have created a private path, Lordship.
Yes, you have shown on.
Yes, Lordship. In their 133 petition itself, they mentioned that private path, no obstruction in the private path. How 133 can be attracted to private path, Lordship? That is only the law point. I'm only on law point, Lordship. If your Lordship satisfied on the citations given by the Supreme Court or the other High Courts, Lordship, your Lordship can exercise the power of 482 in this situation. Oblige, Lordship.
There you have.
Your Lordship is making it saving.
Oblige.
You just collect this one, wildlife and Assam Forest. He matters as it to no follow, hearing to know. But admission will again take time, I think. With the particular counselor there. You were in 1950?
Yes, sir. Lordship, it was a Zimba petition, Lordship. Zimma petition.
Huh?
Zimma petition.
It's a Zimma petition. Who is appeal?
50. Record was called for, Lordship.
Report.
Record.
Record. Why it is a Jima petition, record was called for.
Report.
Report. Ah.
Report not received, Mahmood.
But it is pending since long, in fact. This petition is pending. It key. Why it is listed today?
By order, it has been mentioned. It has been mentioned for this state. It's by order.
Oh, it's by order, no? Oh. Otherwise, the order was passed to list after winter vacation, but by order it has come.
My lord, Lordship may kindly peruse my lord, page number 28, my lord. The order which they have sent in, my lord.
28.
28, last page, my lord. There's nothing wrong with that order.
What articles are what articles? Is that
Motorcycle.
motorcycle?
But I think 28 is about-
Otherwise, they have placed these things before us.
No, Lordship may kindly peruse my lord, page number 28. There is the order dated 6/9.
Yes, this is the order dated that he could not produce any document before
Any
I.
documents, my lord, because if they are the owners of the one motorcycle, then they have to, my lord, produce the documents, my lord.
Lordship,
Peruse
several
the-
times
एक minute,
petitioner.
just a minute. From the report of the IO, it appears that the IO directed the petitioners to produce the documents of the seized articles, which the petitioners have failed to comply with. So the IO could not ascertain the ownership of the seized articles. So what is the
Now,
wrong?
this time, what is your development? Have you approached again?
Several times my petitioners.
Approached before the IO?
Yeah, IO.
Now here you have annexed your documents?
Yes, ma'am.
Which page? Is the one sale letter.
Is number 18. 18 to 22.
Okay, what is the name of the petitioner?
Mehbul Islam, Lordship.
Cases are registered under which section?
And under section 21B, 27, 29 NDPS.
NDPS. The order of the learned magistrate was passed on
6 September.
Hmm?
6 of September.
6/9. Thereafter you have approached.
Yes, ma'am.
Thereafter also you have approached before the IO
Yes, sir.
with documents.
Documents. Lordship.
That's why we need the report, in fact.
Sometime maybe granted.
Or otherwise he may be directed.
The director to Maro appear before the along with the documents, my lord. Only my question is that it's an NDPS case, my lord.
Yes.
If this confiscation proceeding has been initiated, then my lord, his application will be not maintainable.
But we are not in a position to say anything, whether any confiscation, do you have any knowledge in that regard? Whether if any confiscation proceeding has been initiated or is there any?
But my lord, Paras, it is not also mentioned in the my lord report, my lord. The report.
No,
That is,
report, it was not mentioned. What is the present position? That's what I'm asking.
Yes, my lord, present position, my lord, then we have to call for a report, my lord. Because this order, this Hima was rejected, my lord, only because they have not produced any documents before the IO, my lord.
Then say what to do. Tell us. I'm not following you. What you say?
Please fix the date before vacation, Lordship, for a report.
Before vacation for report. No, before vacation, not at all. Question does not arise. No, I'm asking you, if you approach the court, what is the position? That's what we are not in a position to say anything.
No, I don't.
You're saying that you have approached before the IO after that order of rejection. Then what is the present position? Yes, Mr. Borwa, what to do? Otherwise, we have may direct him to appear before, or in that case, matter may be.
Time can be granted, my lord. Remember last time, my lord, we'll obtain a report from the IO. The second question is whether investigation is pending or completed. If the investigation is completed, my lord, or it is pending, my lord, then also there may be some restriction.
You are Mr.
M. Rahman.
I heard Mr. M. Rahman, the London Council for the petition, and also heard Mr. R.J. Borwa, the London Additional PP, appearing on behalf of state respondent. It is submitted by Mr. Borwa that the report is not yet received. Further, he submitted that no, not received, full stop. He further submitted that as the matter relates to NDPS case, there may be the initiation of confiscation proceeding also, but without any report. Okay. And it's submitted that some time will be required to produce the report, and he will personally intimate the IO in that regard. Prayer out, this the matter accordingly. Immediately after vacation, we don't have it. Full matter as a parallel south. 1, 8, 8. Very normative on this. The other matters will be definitely adjourned, but the question is that we cannot give any dates prior vacation. Every dates will be after vacation. We don't have any dates. That is our request.
We have an appeal, 46 number I. We have an appeal, criminal appeal.
It was in hearing.
Yeah, both parties are here. Since 22, I have been mentioning this paper. Since 22. It may be fixed after due vacation. Which one? On 21st of January.
Item number 46.
4:30.
It was a hearing matter, no?
Yes, it is hearing matter. Only appeal against equity law. Already written argument is already submitted. Written argument is both sides have submitted written arguments.
Whether the part matter is part heard.
Part heard.
Before any other court bench.
Before any other bench. Yes.
Then Tata bench will did unity. It is a part heard matter, no.
Written argument is already submitted with both parties.
But it is not a part heard.
Not a part.
46.
Item number 46.
It should be obviously come on either on Tuesday or Thursday, because these are the other days motions and motor matters are also.
Maybe on Tuesday or Thursday.
30 January. 30 January.
30th of January.
Lordship, item number 29, Lordship.
30th of January.
All other matters after vacation. Yes.
The notice written unshared as a remark unknown. So I will be allowed to take their system to trustee service also. That is
Please, Lordship. Lordship, with regard to item number 40, there is an interim that may be continued.
40.
The 29, there is also interim, Lordship, that will be continued, Lordship.
My lord, item number 44.
40 interim was there.
Yes.
40 interim.
29, there is also interim, Lordship.
20.
29.
My lord, item
Item
number
number.
44.
29.
Item number 44.
29 was interim was there.
Lordship.
29 also interim be continued.
Lordship.
My
Obliged, Lordship.
My lord, item number 44. I is for the condemnation and LCR may be called for.
44.
Yes, my lord.
I is for condonation.
Condemnation? Yes.
Then
Lack
we
of
cannot-
publication and then
We cannot call for the LCR. Let the matter be. This is the condonation is the unless and until your
condonation-
matter is condoned, your petty LCR cannot be called for. Cannot be called.
That may be given
That will see. All will after vacation only also. 36, what to do? In item number 36, interim is there. 36, huh? Interim will be continued till next date of. Okay.
34, actually, we want to withdraw that because your lordship state the proceedings of the interim maintenance, but the trial already been concluded in the Principal Judge Family Court. Now the court has fixed a date for judgment on 18. So we want to withdraw because matter has become infracture.
Infractions. 34.
34, yes.
30. You are for the petitioner?
Yes, lordship.
Petitioner side, the case has already been fixed for judgment and accordingly the present petition has become infructuous and accordingly withdraw, praised to withdraw the same. Okay, will be disposed of on withdrawal.
Lordship, regarding item 43, Lordship, case diary was called for because it is for quashing of the proceedings, Lordship. Case diary is there, Lordship. May I pray, Lordship, can it be taken after vacation, Lordship, or after view vacation, Lordship? Any date fixed?
Case diary cannot be retained, I think, na?
Because then
After
Lordship,
vacation, can it be retained?
then can it be before vacation, Lordship, since case diary is
Before vacation, to not at all possible. Because if you return back, probability of receiving again, sometimes it happens. But till say almost 1 month will be there then.
Not third is 5, 6, not 10, 9.
6.
Then if CD can be retained till 6.
Yes.
On item number 43.
43.
CD received. 6 dot corridor 6/1/2025. CD be retained till next date of listing. Okay, will be retained in CD.
Highly obliged.